Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7157 et al. Trustees of the IM National Pension Fund versus M&K Employee Solutions, LLC, appellant, and case number 23-7028, Trustees of the IM National Pension Fund versus Ohio Magnetics, Inc., et al., appellants. Mr. Keneally for the appellants issues comment to all appellants. Mr. Vogel for the appellants, free look exception issue. Mr. Roberts for the appellee.
Good morning, Your Honors. May it please the court, my name is Michael Keneally. I am arguing today on behalf of all the defendants on the actuary assumptions issue in this case. Mr. Vogel will be arguing on the free look exception, and I'd like to try to reserve 2 minutes for rebuttal if possible. Your Honor, Section 1391 provides that withdrawal liability must be based on unfunded vested benefits or UVBs as of the measurement date. By its plain terms, this means the UVB's calculation must reflect how things stood on the measurement date, not anything that occurred after. Here, however, the fund undisputedly assessed liability using a UVB's calculation that was based on developments after the measurement date. The basic facts on this aren't in dispute. On December 31st, 2017, plan's actuary, Chiron, endorsed a 7.5% discount rate for withdrawal liability and no administrative expense load. Chiron had just applied these exact assumptions 2 months earlier on November 2nd in the 2017 valuation report. And a few weeks after the measurement date on January 24th, Chiron presented the same assumptions to the trustees as the current policy. Only then did Chiron change the December 31st assumptions with the trustees' input. And those new assumptions had the effect of increasing the fund's UVBs by a multiple of about 6. This calculation of UVBs based on developments after the measurement date violates Section 1391, as the only other circuit to address this question has held. To calculate UVBs as of December 31st, an actuary must use the assumptions that the actuary deemed appropriate on December 31st. It may not use contrary assumptions that reflect events after December 31st merely because it later adopted different policies and objectives.
Can I ask you a hypothetical? Imagine that a company has 100 employees, but on the measurement date, the kind of auditor or whoever kind of comes up with these type figures is only aware of 80. And then a week later, he learns, oh, they hired 20 more before the measurement date. So now there's 100 employees. Would the calculation for liability as of the measurement date be able to factor in those extra 20 employees?
Your Honor, we don't dispute that the assessment of withdrawal liability needs to be based on the actual real-world facts that existed that day. But actuarial assumptions aren't just a dry objective assessment of the objective facts. As this court explained it in Energy West, as applied to the discount rate assumption, the assumption is going to estimate how much interest the plan's assets will earn based on their anticipated rate of return.
And I get the kind of labeling difference there, but if what's supposed to happen is the actuary figures out, okay, there were actually 100 employees, even though I only knew about 80 on the measurement date, why shouldn't the actuary ask himself or ask herself, okay, the discount rate, and the most accurate, reasonable, this term from the statute, reasonable discount rate on the measurement date turns out to be 6.5%. I would have thought, back in November, a month before the measurement date, that it was 7.5%. But now that I kind of have all the information that would have been available had I known everything up to the measurement date, put labels aside, why is the employee's hypothetical different than the discount rate facts of this case?
Sure, 2 points on that, Your Honor. The first is that the actuarial assumption about the discount rate isn't going to be based on how many participants are in the plan. It's based on the investments held by the plan and the anticipated rate of return. But then the second and possibly more substantive answer, I think, to Your Honor's question is that the actuary here described the change in actuarial assumptions in 2018 as based on policy. And that's, I would particularly recommend that the court review the PowerPoint presentation that Chiron presented on January 24th.
That seems like if it was a mistake, it goes to the question of whether the discount rate was reasonable or not. It doesn't seem like it goes to the question of what events was the actuary allowed to consider kind of in between the last time a discount rate was calculated, November, and the measurement date, December 31st.
Well, it's both, I think, Your Honor. And for this case, the only one of those two questions that's relevant is the timing issue. But it does go to timing because, as this PowerPoint presentation explains, there are policy ramifications to different actuarial assumptions.
You can argue that, the arbitrator and then eventually to the district court again. And I think you will probably have some really strong arguments that the gap drop from 7.5 to 6.5 was unreasonable, especially because it seems like the actuary wanted it to be 7, and then there was some kind of like smoke-filled room and they went into it and they came out of it, and voila, it's 6.5. But that's not our case.
Well, it's not just the reasonableness, Your Honor, because as this PowerPoint presentation says, it's a question of the trustees' input. And that's at page, I think it's at 239 potentially of the joint appendix. 236 is the discount rate is determined by the actuary with the trustees' input. And here the parties stipulated that it was only following discussion with the trustees. This is at joint appendix 39, and this is the Ohio Magnetics joint appendix. That the change happened. And I think especially when you have a decoupling of the funding discount rate from the withdrawal liability discount rate, that is inevitably going to be a policy-based determination because they're supposed to be measuring the same thing, as this court pointed out in Energy West.
Those points don't go to the legal question before us about whether the actuary can make a determination after the measurement date based on assumptions in place at the time of the measurement date.
I think it does go to the question, Your Honor.
How does it relate? Because there seem to be a lot of, factual things that are alleged that sort of suggest some kind of wrongdoing. And again, maybe as Judge Walker said, you can raise those before the arbitrator. I don't know if they were properly preserved in the arbitration, but how do they go to the legal question we have to decide?
They're not just about wrongdoing, they're about timing because on December 31st, the actuary had a set of actuarial assumptions that he thought were the best estimate of anticipated plan experience. And then only after that date, which everyone agrees, the measurement date is the snapshot date and withdrawal liability must be fixed on that date. Only afterwards did he revisit that.
So what is the exact problem? Is the problem that an actuary can't be trusted to look at the assumptions on December 31st after December 31st? Or is your contention that that didn't happen in this case? Because those are, it's not clear precisely what the problem is, because you agreed with Judge Walker that you could understand the number of beneficiaries after December 31st to accurately update for the amount of beneficiaries. Why can't the same be true for actuarial assumptions?
Well, we're not making just a policy argument here, Your Honor, about there being a problem that Congress would need to address. We're saying that as 1391 is currently written, there's a freezing of UVBs. Under Combs, the UVBs are fixed on that date. And if the UVBs change on that date based on things that happen afterward, they're no longer fixed.
It's a question of whether I agree with you that the statute says the UVBs must be fixed. I take the question here to be whether that fixed amount can be calculated after December 31st.
It's not just whether it can be calculated after December 31st, it's whether it can be calculated based on actuarial assumptions that were different.
Can it be calculated after December 31st?
Yes, it can be calculated after December 31st, but the statute defines UVBs. This is at 1393C as the value of non-forfeitable benefits under the plan less the value of assets. And the value of non-forfeitable benefits is going to be the present value. So by the definition of UVBs, the actuarial assumptions are baked in. You can't get the present value of future benefits without an
Maybe
actual.
my pronoun in my last question occurs to me might have been imprecise. Can the discount rate be calculated after December 31st?
No, not if the discount rate is going to be different than the one that was in place on the measurement date. And that's because the UVBs on that measurement date are by definition a function of actuarial assumptions as applied to real world facts.
We're
And
not disagreeing that the information available as of 12/31 is the information on which any of the assumptions should be made.
but the actuarial assumptions that were adopted in January weren't based solely on the information available on December 31st because they depended on this meeting with the trustees where the trustees
But I'm
provided their
asking,
input.
do you agree that it should be based on what was available as of December 31st, even if calculations come later?
Yes, there's no question they cannot be based on information that wasn't, in our view at least, maybe the fund disagrees, but you cannot consider any information that arose after the measurement date. And even the district courts here agreed with that. But our point is that it also can't be based on a change in policy direction that occurs after the measurement date. And here the
I
actuaries
just don't see how we can't say, maybe you're right about that, but that's not the issue presented in this case.
It is the issue presented in this case because the question is whether those actuarial assumptions are different from the ones that were in place on the measurement date. And there's no doubt that they were. And part of the reason why, and this is at page 238 of our joint appendix, the actuary explained that there are different practical effects in differences in actuarial assumptions. If you have a more conservative discount rate, you give more protection to ongoing employers. Then they had this executive session with the trustees, and afterwards they adopted a different rate that wasn't even one of the rates that they had modeled in their presentation, and set aside whether any of that was wrongdoing. That's not the issue for the court. What is clear, though, is that it is a change that happened after the measurement date, and that but for that change would not have affected the measurement date that was in place on December
I thought the
31st.
question presented here is not whether assumptions and events, considerations after the measurement date can be factored into the discount rate. I thought the question here was there was a discount rate calculated in November. The measurement date is December 31st. And the question is, after December 31st, can an actuary consider stuff that happened between November and December 31st when calculating what the discount rate was on December 31st? I thought isn't that the question?
I don't think so, Your Honor. And there's no dispute here, but the actuary can account for information that arises from one actuarial evaluation report to the measurement date. And there's nothing that would have prevented Chiron from updating the discount rate or any other assumptions before 12/31. The only question here is whether the actuary can decide with the trustees' input to change policy direction and be perhaps more conservative in the discount rate to provide more benefit for ongoing employers.
I think you just have to be clear about so are you saying that the rate that was chosen in January is not even on its own terms trying to measure what the discount rate was on December 31st?
Well, that would be the
Because-
later question that would have to be decided if this case, if we lose on the timing question.
So you're not arguing that.
No, we're arguing though that it is a rate that is not just a dry objective. And I
Because
think
you
this is
agree
what,
that in January, you can look backwards and calculate a discount rate as of December 31st?
no, we're saying you have to use the discount rate that's already one you hold on December 31st. You can apply that to facts. I'm sorry?
There wasn't an actuary working on New Year's Eve and deciding, okay, this is the discount rate today. The discount rate was calculated in November. And then I think I heard you say a couple minutes ago that you don't have any problem with us holding that an actuary can update the discount rate after December 31st, so long as the actuary is only considering things that happened before December 31st.
No, Your Honor, I did not say that. I
Okay,
said that they
thanks.
can apply their actuarial assumptions on December 30, the ones that they have on December 31st, to facts, real world facts, like the number of participants and how much those participants benefits, what benefits they're entitled to under the plan. They can apply the old actuarial assumptions, the ones on the measurement date, to facts that don't get revealed until after the close of markets on the measurement date.
Why is the actuarial assumption not a fact in the world on December 31st, like the number of beneficiaries? Like you agree that things like the number of beneficiaries, you can, make sure you have the right number as of December 31st, and you could verify that in January. Why can't you do the same thing with the actuarial assumptions? I mean, I take that to be in part what Judge Moss says in his opinion, and that seems, I don't know, fairly reasonable.
Well, I agree. This is a very important point. I think the district court's been off track on this very point. And the reason why it's not a fact that just exists out in the world is because, as this court explained in Combs, actuarial evaluations are based not just on plan experience, but also the professional judgment of the actuary and the theories and expectations to which the actuary ascribes.
Back to my earlier point, is it just that we don't trust the actuary in January to properly figure out what the actuarial assumptions were in December? Is that your conclusion?
Well, I wouldn't put it in terms of trust, Your Honor. I would put it in terms of a new thing is happening after the measurement date that's dispositive.
But you said that question is not before us. You said the question is not before us whether the actuary in January was using, information from January. I mean, we're just focusing on the legal question of whether the actuary can try to calculate the assumptions in place on December 31st in January.
Well,
I mean, the actuary may have done that incorrectly or unreasonably, but that's not the question before us.
Well, I think the question before you is whether those actuarial assumptions are really just like a reflection, like a mirror image of facts that exist in the world, or they're an actual new occurrence because the actuary is looking at those facts and forming a judgment
So you're
about.
saying it's impossible to determine actuarial assumptions at a date in the past? Like that's not something that can be identified.
I think it's always going to be anachronistic to say at time X that at time X minus 5, actuarial assumptions were whatever you're saying in the future.
Because of the nature of actuarial assumptions?
Exactly. They're very laden with policy decisions, as Chiron's own PowerPoint presentation to the trustees acknowledged. And I think I just want to note that there's no dispute here, and this is at JA 700, the undisputed facts at summary judgment in our case, that there had been no change to Your Honor's question about whether the actuary actually had an actuarial assumption on December 31st. The parties were not, they stipulated, or there was an undisputed statement of facts that says there had been no change of the actuarial assumptions before 12/31, and that's at page 700 of our joint appendix. So I don't think that there's. The other point I would make, Your Honor, is that the PowerPoint presentation also reflects those 2017 assumptions as quote unquote current policy. And on page 246 of our joint appendix, Chiron reaffirms that the assumptions reflect our understanding of the likely future experience of the fund, and the assumptions taken individually represent our best estimate for the future experience. So there's no
Let's say that you're entirely right. This was a terrible PowerPoint presentation. They considered all kinds of things that they weren't supposed to consider. Those are facts specific to this case, and we have to say what the statute means, and that will apply to all other cases. And I think that the implication of your argument is that if the last time there was an update to the discount rate was in November, and then a pandemic hits on December 25th, then in January, an actuary calculating the discount rate on December 31st has to pretend that the pandemic didn't happen. It's just close his eyes to that event. Is that the implication of your argument?
That is the implication, but it's not that odd, Your Honor, because remember, discount rates and other actuarial assumptions are supposed to capture decades worth of future projections. It's not just going to be about the state of the market at a given point in time. And also, even under the district court's view, that sort of mental gymnastics would be necessary if that pandemic hit on January 5th. So it's going to be difficult for the actuary to do that calculation.
You don't require them to close their eyes to the additional 20 employees that were hired in my hypothetical, even if they didn't know about them the last time that kind of everything.
No, because that's just numbers. Those numbers will come in, we'll know what the values of the accounts were after the close of markets on December 31st. And those numbers aren't susceptible to movement one way or the other. They are what they are, but the actuarial assumptions by their nature are not. They are dependent on the views that the actuary is holding at the time, possibly the views of the trustees, but set that aside. And they are therefore not the kind of thing that just exists as a brute fact out in the world. And I see I'm over my time, Your Honors. Mr. Vogel would be happy to address the free look exception. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is Don Vogel and I represent M&K Employee Solutions. Kind of doing a little backwards here because M&K is actually the appellee in the fund's appeal of the 5-year free look issue. In the short amount of time I have with you, I'm just going to address that 5-year free look issue and confirm that the district court did hold that it's applicable to M&K. What the trustees try to argue is that there should be an additional requirement written into the statute, and that is not only must a employer like M&K partially withdraw within 5 years, but it must also completely withdraw within 5 years and stop participating. It tries to argue that if you uphold the district court's decision, it will promote fractionalization among employers like M&K. And the statute actually cures that by treating all trades or businesses in common control as a single employer. So the mere fact that one of M&K's series entities partially withdrew and another entity continued to participate beyond the 5-year free look time is of no moment, because the statute specifically provides that a partial withdrawal is included in the 5-year free look exception. So that when you walk through the statute like the district court did, and you look at all of the elements which the fund agrees M&K has met, you will find that they are entitled to the 5-year free look. And in fact, as we are remanded to the arbitrator, that treatment is such that the contributions of that particular entity should be excluded from the calculation of the subsequent complete withdrawal. If you have any questions, it's a pretty straightforward issue.
Okay.
Very well, thank you.
Thank you very much.
Good morning, Your Honors. May it please the court. My name is John Roberts from the firm Proskauer Rose, and I represent the trustees of the IAM National Pension Fund. I think based on appellant's presentation, there's a little bit of confusion as to what the issue is before the court today. The issue before the court is a pure legal question. Does Congress require actuaries to select their assumptions on or before the measurement date? That is a purely legal question. That is the only question that was presented to the arbitrator below. It does not turn on the facts of this case at all. It applies, as Judge Walker noted, to every case that will involve calculations of withdrawal liability. And I think it's important to note there was no factual development below because there was just this legal question presented to the arbitrator. So all this talk about PowerPoint presentations and smoke-filled rooms, there's been no factual development on any of these issues. To the extent appellants want to argue that there was something untoward occurred and that it was the plan that somehow manipulated the actuary into selecting it. They can, to the extent the arguments are preserved, they can make those arguments on remand. But that's not for this court to decide. The issue for this court is, did Congress intend to require actuaries to select the assumptions they used to calculate withdrawal liability before 11:59 p.m. on the measurement date? And our view is that that proposed deadline has no support in ERISA's text. And in fact, it would conflict with the statute's best estimate requirement. Congress gave actuaries one directive when selecting their assumptions. They're supposed to use assumptions that reflect their best estimate of the plan's anticipated experience. Appellant's proposed deadline can't be reconciled with that best estimate requirement. Just take this case as an example. The actuary here determined the assumptions that reflect its best estimate of the plan's anticipated experience. But under appellant's theory, the actuary wouldn't be allowed to use those assumptions because they were selected a mere 3 weeks after the measurement date. Instead,
But Mr. Roberts, do you agree that the assumptions, that the actuary has to use assumptions that were in place on December 31st, has to look backwards and try to figure out what the right actuarial assumptions were as of that date?
Yeah, I just want to be careful about that term "in place," right? That's appellant's position. Appellant's position is that there had to be some sort of
in place that the actuary in January, when figuring out the discount rate, has to look at the conditions or the economic conditions at the time
Correct.
of December 31st.
Yes, that is our position, and that is what occurred here, which will be shown on remand if that ever gets litigated later. These assumptions were selected 3 weeks after the measurement date, and they were based on the information that was in place on the measurement date. But that's for the
If
remand.
the calculation was made 6 months, it was made in June of the following year, would they still have to look at the economic conditions in place as of December 31st?
Yes, so yes, Your Honor, and that's our position, and that's the position that the district court took below. Now, I want to be clear about something. The question presented to this court is, do the assumptions have to be selected on or before the measurement date? If you agree with us on this, that raises this secondary question as to what information the actuary can use when making that selection. And there's two options. Either they have to use the information available on the measurement date, or they can use information up to the date of the calculation. We're ultimately agnostic on that second question, because if you even get to that second question, you've already agreed with us that they're allowed to select the assumptions after the measurement date. And either way, we will prevail, because here, as I said, the facts will show that nothing material happened between the measurement date and the 3 weeks later when the actuaries selected their assumptions. There's no reason to think that Congress wanted actuaries to select their assumptions before the measurement date, given that complete information about the plan isn't available until after the measurement date. As this court explained in the Energy West case, an actuary's best estimate is supposed to be based on the plan's actual characteristics and experience. But complete information about a plan's characteristics and experience through the measurement date typically isn't available until after the measurement date, and it takes time to gather and analyze that information. So a best estimate of a plan's anticipated experience typically can't be made until after the measurement date. Appellant's proposed deadline would force actuaries to select their assumptions before all the information about the plan year is available, which not only doesn't make any sense, but it would mean that the actuary's assumptions probably, in some cases, won't reflect its best
Mr.
estimate.
Roberts, let me ask you a question about something you said a couple minutes ago about that secondary question. You said we don't have to reach it. I think both district court opinions on a review did reach it. And if we affirm, won't we be endorsing the district court's answer to that secondary question?
Your Honor is correct that the district court did decide that question and said that the actuary is supposed to consider only information up through the measurement date. I mean, the court can write the opinion anyway. It decides to write the opinion and make it clear what its position is. But my point is that if you even get to that question, we've already won the case, because that only comes up if the actuary is permitted to select the assumptions after the measurement date. And in this case, there's no issue there, because the assumptions were selected, as I said, a mere 3 weeks.
But future district courts are going to need to know what to do. And I think your opposing counsel would have a decent argument that if I remember right, you did not cross appeal on this issue. Am I remembering that right?
That's correct.
And so arguably you've abandoned the position you took below, that the answer to the secondary question is that the actuary can consider events that occur after the measurement date. So I think you've abandoned it, and therefore we affirmed the district court. We would be telling future district courts to do what the district court did here. Do you agree with all that?
I do agree with all that, Your Honor. And we're, like I said, we are perfectly okay with that. This is the position we have taken on appeal.
Take the win.
We are arguing the narrower issue because we will win under the narrow issue. If the court chooses the broader ruling, we're fine with that as well. But I take your point that guidance would be helpful in future cases. So if the court wants to answer that question, like I said, we're agnostic as to what that answer is. Appellants claim that their proposed deadline is mandated by 29 U.S.C. 1391, but that section says nothing about actuaries or assumptions. Their entire textual argument can be boiled down to the following logic. Section 1391 requires withdrawal liability to be calculated as of a measurement date. Okay, we agree with that part. But here's the logical leap. According to the appellants, the only way to calculate withdrawal liability as of a measurement date is to use assumptions that were selected before the measurement date. But that's just simply not true. As of doesn't mean that all of the inputs used in a withdrawal liability calculation must be compiled before the measurement date. As of just means as things stood on the measurement date. The actuaries talk about this in their amicus brief. As of is a term of art that comes up regularly in their field.
Before your time runs out, I want to ask you about the free look.
Oh, sure.
exception.
Happy to turn to that.
If I remember right, I could be misremembering on this. I think you suggested that your reading of the free look language does not render the partial withdrawal text irrelevant because it would do the following work. An employer withdraws completely before the end of 5 years, say. But there was originally a 90% partial withdrawal, and then before 5 years was up, there was a 10% partial withdrawal. So, or withdrawal of the remaining 10%. And according to you, the employer would only get the benefit of the 10% withdrawal if it weren't for the partial language. I have follow-up questions, but am I following that argument correctly, that theory correctly?
Yeah, I think you generally have the gist of it. The idea is that there is a possibility that an employer withdraws in stages within the free look period. So I think your hypothetical covered that, right? There's a let's say a 90% withdrawal in year 1 and then a 10% withdrawal, in year 4. Upon the partial withdrawal, there will be an assessment of partial withdrawal liability. And then upon the complete, there'll be an assessment of complete withdrawal liability. The reason that the statute mentions both is because the free look can apply to either of them. If it just said something about complete withdrawals, there would be a question as to whether or not the partial withdrawal would be entitled to the free look. So I think there's a lot of—
There'd be a question of whether the 90% in my hypo or the 10% would be entitled.
The 90, because in your hypo, that's the partial,
It seems
right?
very odd that you need the insertion of the partial text in order to do that work, because after the 10% withdrawal, there would have been a complete withdrawal at that point. And then it seems like, at that point, the arbitrator, the actuary, the decision maker would say, look, there's been a complete withdrawal, so you're entitled to all of the benefits of the free look exception.
So there's another provision of 1390. I think it's subsection A4. I don't have it in front of me. I apologize. But it talks about how you can only use the free look once. And so it's not true that you have a seriatim withdrawal that you can just keep using the free look each time.
No, you would get the credit for it after the complete withdrawal, after the 10% makes the withdrawal complete.
But they're separate assessments. That's how it works. So there'd be a partial assessment, which would be paid starting in year 1 in this hypothetical. And then later there would be a completed withdrawal assessment. Subsection 4 says you can only use the free look for one of those.
Okay.
Any other questions? Thanks very much.
Okay. I'll give you 2 minutes on rebuttal.
Thank you, Your Honors. Under the fund's view about actuarial assumptions in the statute, there is no temporal deadline for adopting actuarial assumptions. Doesn't have to happen by the measurement date, doesn't have to happen by the withdrawal date. It could happen over a year later. And not only that, if there are multiple withdrawals, I think under the fund's view, the actuary could adopt different assumptions, different discount rates for each employer's withdrawal, because at each point in time, under this theory, they would still be looking back in time to what existed on December 31st, but there's no limitation on their view about the different ways they could look at that or the different policies they could choose to adopt at future dates. And I think that reading of the statute really takes as of the language from 1391 out of the statute altogether. Because if you can have different assessments of UVBs when different employers withdraw in the next calendar year, you're no longer fixing UVBs at that measurement.
They're not necessarily pressing that point anymore, right? Because they say they're agnostic on what information can be taken into effect. So if this court were to rule, like the district court did, that you can calculate the actuarial assumptions after December 31st, but relying on information available on December 31st, then the situation you're describing wouldn't occur.
Well, I think it depends on how you write that opinion, Your Honor. And I think it would be really important if that's the view that the court takes rather than the categorical rule of the Second Circuit. I think it's really important even in that situation to clarify that nothing other than the facts that existed on December 31st and were reasonably available could be considered. That means no input from the trustees could be considered that happened in January, because that's not anything having to do with the facts that existed on December 31st. And I think that's a very important point, because if we're going to indulge in the idea that you could still put yourself back in time on December 31st, I think the actuary still, under that approach, would need to block out any input or change of direction that came from another source after December 31st.
I know the free look issue was Mr. Vogel's and not yours. It may not even be your client that is.
I don't have a client that has a dog in that fight, Your Honor. But I'm sure Mr. Vogel would be happy to.
I just asked.
Okay, thank you, Your Honors.
Thank you.
My only question is, can you just respond to the theory that the opposing counsel floated about why the partial withdrawal language would still do work under his theory of the free look test?
Well, their theory of the free look is that it should only apply if you are withdrawing in a series, in a bunch of stages, as long as you complete the full withdrawal before the end of the 5 years. But simply, that's not what the statute says. The statute says that you are entitled to it in either a partial or a complete withdrawal. So in the scenario that you gave that they have in their papers, where they had that first 90% partial withdrawal, that would be subject to the free look because the statute says so.
Okay, so it sounds like you may be completely right. It's possible for you to be completely right, and also for him to be correct.
Well,
if his theory were correct in this case, it's that partial withdrawal text would still be doing some work under his theory.
it would.
Okay.
It would.
Doesn't mean he's right, but it would.
And he's not.
Very good.
Very
I'm grateful.
Thank you.
Thank you. Case is submitted.
Case number 20-1283 et al. New York Power Authority, Hudson Transmission Partners LLC petitioners versus Federal Energy Regulatory Commission. Mr. Townsend for the petitioners, Ms. Chu for the respondents, Mr. Longstreth for the respondent intervener.
Okay.
Good morning, Your Honors. My name is Lucas Townsend, and I'm arguing for petitioners Hudson Transmission Partners and New York Power Authority. And with the court's permission, I'd like to reserve 2 minutes for rebuttal. The orders on review require Hudson and its customer, the New York Power Authority, to pay roughly $12 million per year for 40 years for rights they do not actually have and benefits they no longer receive. Plain language of the controlling tariff, the PJM tariff, forbids this result. And I'll begin with the lower voltage projects, which represent the lion's share of the contested costs in this case. The lower voltage projects are governed by a provision of the PJM tariff, section B10, B2, and it's found at Joint Appendix page 499. And the relevant language says this. It says, transmission provider shall base the collection of transmission enhancement charges associated with required transmission enhancements from a merchant transmission facility on the actual firm transmission withdrawal rights that have been awarded the merchant transmission facility. That's at JA 499. In other words, the collection of charges from a merchant facility shall be based on its actual firm rights, not prior, not deemed, but actual. So if there are no actual firm rights, there cannot be a collection. And the fundamental error that the agency makes in this case and in the orders below is that it conflates cost assignment with collection. Those terms do not mean the same thing. And this court held as much just last year in a strikingly similar case, Long Island Power Authority versus FERC, 27 F4th 705. And in that case, this court addressed the meaning of the word collected in another provision of the PJM tariff relating to merchant facilities. That provision was Schedule 12C. In that case, if charges were collected, then the merchant facility would be responsible for adjustments under that provision of the tariff. And FERC had argued that the word collected in that case meant to accrue liability for the assignment of costs. This court rejected FERC's interpretation in that case, and the court relied on the plain meaning of the word collected. Collect as meaning to call for and obtain payment of. That's at page 716 of the LIPA decision. And the court said FERC has not identified a single example in a dictionary or otherwise where collect means to accrue liability, nor have we found any. And the court also found support in the surrounding provisions of that tariff provision. There are provisions in that case that called for deferred charges. There's a difference between what was collected and what the settlement called for, and they were essentially deferred charges.
But that section seems different, right, from what we have here. I mean, subsection B is about when there are less firm rights than, when a company has less firm rights than they will eventually have, right? It doesn't speak to the situation here where there are no firm rights, at the time the costs were assigned. Right, so that analogy doesn't seem to work here.
Well, I think this provision actually, I mean, it's the facts are slightly different and the wording is slightly different, but I think that the analogy does hold up because this provision is a parallel to the one that was discussed in the Long Island Power Authority case. The tariff provision at issue in this case, section 12B10, defines the difference between what is assigned and what can be collected, and it's defined as a deferred charge. And that deferred charge shows up in the account books of PJM, the grid administrator, the grid operator, as something that is kept track of. Eventually, it may become due, but it cannot be collected except on the basis of actual firm rights. In this case, there are zero firm rights, no actual firm rights. Under the plain text of this provision and the meaning of the word collected, there can't be collection of those charges unless and until there are firm rights. And in the meantime, they are just deferred charges.
But that's why this isn't really an analogous situation, right? I mean, here the lower voltage facilities charge was calculated using the old method, right? The violation-based defects, right? Yes. And that was set at a certain time. It was like the charges for those firm rights. And so how do you get out of those charges now?
Well, so this goes to the distinction between what is assigned and what is collectible. So the provision that sets those charges that the commission has relied on is provision A5. And it says, except as the relevant language says, and this is at page JA 489, except as specifically set forth herein, nothing in this Schedule 12 shall change the assignment of cost responsibility or classification of required transmission enhancements included in the tariff Schedule 12 appendix. And the argument is that those listed assignments are fixed and unchanging. And our position is that under 12B, it's entirely possible that those are fixed and unchanging, and yet 12B10B2 still applies to make those charges uncollectible. They're uncollectible and they show up as deferred charges under the procedures that are surrounding 12B10B1 and 12B10B3 provide for deferred collection.
If I agree with what Judge Rao just said about BX, B2, BX. But I think FERC didn't rely on that reasoning in its decision-making. What do I do with that?
Well, the FERC didn't have really any reasoned rationale that can be upheld in this case. FERC simply said that 12 B10 B2 doesn't apply, full stop. They read 12 A5, said that applies, and they simply didn't grapple with the text of 12 B10 B2. In that instance, it's a failure of reasoned decision making, and the orders have to be set aside under the APA as arbitrary and capricious. And we would submit that the plain text, the unambiguous text of 12 B10 B2 forbids the collection of these costs. So it's not something that the agency can reinstate on remand. This court has already done the work in the LIPA case to determine what collect means in a strikingly similar context.
If B10 does what you say, why did Con Ed need B11?
So that B11 was put into the tariff as a result of a settlement, a 2009 settlement with Con Ed. It involved a number of parties, not Hudson, not the New York Power Authority. But that was addressed in a separate proceeding, and part of that proceeding resulted in an amendment to the tariff.
I get all that. I mean, I follow that, but all that can be true, and it could still be the case that if B10 does the work you say it does, Con Ed could have just relied on B10 being added to the tariff and wouldn't have needed B11 to be added to the tariff.
B10 is a provision specific to merchant transmission facilities. And so Con Ed is a utility. It's also an entity outside of the PJM region. So it required its own special provision here as a result of the settlement. This B10 is only with regard to merchant transmission facilities, and there are just 3 of those.
How does B10 though? I mean, so I guess A5, right, under the effective date, says very clearly, except as specifically set forth herein, nothing in the Schedule 12 shall change the assignment of cost responsibility in Schedule 12 appendix, right? So how does B10 do that work of specifically allowing for a change to the Schedule 12 appendix?
Well,
I think that it's a tough read.
So I would say 2 things. First of all, that we don't even need this as an exception because it's possible to read both of those provisions. They address different topics. The A5 addresses assignments. B10, B2 addresses collection, different topics. If we are talking about a reallocation of the charges.
Hairs a little bit though.
Well,
I mean, if it says you can't change the cost responsibility, but then you're just going to read B10 to say, oh, well, we're not changing the responsibility. We're just changing the collection. I mean,
well,
a little bit. I mean, it's maybe clever, but I don't know.
Not at all, Your Honor, because that's what the tariff actually provides. It provides for deferred charges. It contemplates that charges can be assigned but not collectible. And they go on to the accounts of PJM. I'll quote the language in particular. This is section 12B10B1. Transmission enhancement charges allocated to a merchant transmission facility, so allocated, for which collection is deferred in accordance with this section shall be recorded in appropriate transmission provider accounts for deferred charges and collected in accordance with the procedures set forth in 3. That's at JA 499. So the tariff itself defines the difference between what is assigned and what can be collected. And it was exactly that same situation also existed in the LIPA case. This is
if what matters here is collections and not assignments, does that hurt your opinion 503 argument? Because I think opinion 503 talks about assignments.
Yes.
Collections.
We have a separate argument that there should be a reassignment as well. And so if we can step back and just remember how this arose. This arose because PJM made a compliance filing and it proposed to change the assignments and zero out the costs for merchant transmission facilities that no longer had firm rights. And we submit that was correct as well under the commission's precedent. Exactly the same thing happened with respect to the Con Ed settlement. Con Ed allowed its firm service to expire. And at that point, and there is a provision that in the tariff that allows for the costs allocations to go to zero for Con Ed. There is no provision in the tariff, though, for reassigning those costs onto other parties. And what happened was PJM just proposed a pro rata reallocation at that point on all other parties, and FERC approved it. That methodology is not in the tariff. PJM proposed exactly the same pro rata reallocation for Hudson and for NYPA in this case, and FERC said no. And we submit that that was error. That was inconsistent with FERC's longstanding policy, both under the Con Ed example and also under Opinion 503, which recognizes that costs can only be assessed on merchant transmission facilities to the extent of their firm rights.
Are you making an argument that FERC failed to treat like cases alike?
Yes, with respect to the
is that in your brief
well,
or
with
not?
respect, it's the departure from longstanding policy. The longstanding policy is that only merchant facilities with firm rights can be assigned costs, can be assessed costs. And that was true in Opinion 503. It was also true with respect to the policy, the December 15th, 2017 orders that allowed Hudson and Linden to convert from firm rights to non-firm rights. And it was also consistent with the practice in immediately following the Con Ed settlement.
But the 2017 order says that, you can't impose the solution-based defects.
Correct.
Going forward. But solution-based defects is sort of, by definition, it's sort of an ongoing charge. So it makes sense that you can't continue to allocate the solution-based defects without any firm rights. But that doesn't necessarily tell us what to do about the violation-based defects charges that were imposed at a set time.
Well, that's where we again go to the Con Ed example. So the costs that were reallocated were the supposedly fixed costs. Our fixed costs went up after the Con Ed settlement. There was no methodology whatsoever, and PJM did a
Do you raise a like cases alike claim in your brief? I didn't see that.
Well,
Because that's a distinct claim under case law, a distinct kind of arbitrary and capricious agency action.
It's within our argument that FERC has disregarded its longstanding policy, and we do rely on the Con Ed example as an instance where the agency did approve this exact reallocation, and then didn't allow for that reallocation in our case. So, but that again goes to the reallocation point. And there's a separate point about whether the allocated costs are collectible, because it's entirely possible that the Schedule 12 appendix allocations are fixed and unchanging, but they can't be collected. And that's what 12B10B2 says.
You indicate you don't receive any more benefits. That's how you started out.
Yes.
Go a little bit more there.
Certainly, Your Honor. So the measure of benefits is firm transmission withdrawal rights. And those rights are special because they can't be curtailed except in very extreme circumstances. And that is the traditional measure in Opinion 503 of the benefit that a merchant transmission facility draws. That incidental benefits, whatever incidental benefits parties draw from changes made out in the grid somewhere. Some of these projects are in the Chicago area, hundreds of miles away. Incidental benefits aren't the basis for cost allocations under this tariff and under Opinion 503. So the argument that I think the other side has made is that there are still incidental benefits coming from these projects, but those aren't the measure of benefits under Opinion 503, and they aren't a basis for cost allocations. And Hudson has paid very extensively for interconnection. They paid $335 million to interconnect to the PJM grid. That investment is completely lost. We walked away from that in order to stop the bleeding in this case, but all of those improvements are still in the PJM grid. We also paid for firm rights when we had those firm rights in the period where we had those. We pay a separate rate called the border rate, which is an export rate. We also pay for the electricity. So whatever incidental benefits can be said to be drawn from the grid, we've paid for. We've paid for, and the firm rights are the only measure for cost assessments under this provision. I'm over my time. If I am happy to.
No, That's fine.
I'm happy to answer.
I have a
Oh,
chronology
yes.
question.
Yes.
I think that your brief says that you didn't acquire the firm rights until 2015. Is that right?
The full allocation of firm rights was
Maybe
in
that's the answer
2015.
to my question, but the violation-based costs were assessed from 2007 to 2013, I think.
I believe the costs were assessed from 2013 to present. The projects were planned from 2007 to 2013. So that was the planning period for the projects.
But then the costs get assessed after you have acquired your firm rights. in
Correct.
2015.
Correct.
Okay,
That's correct, Your Honor. I'm happy to address economic projects briefly if there are any questions.
You can say a little bit about that.
Yes. The relevant provision for the economic projects is 12(5)(c). So there are three types of economic projects, A, B, and C. And 12(5)(c) governs the projects at issue here. That provision does not mention merchant transmission facilities, in contrast to A and B. A and B say costs can be allocated to zones and merchant facilities. C says merchant facilities, full stop. There's no provision for the allocation to merchant transmission facilities. Now, the way that FERC has justified the cost assignments is to say, well, merchant facilities are like zones, but they're only like zones if they have firm rights. And that's the policy of opinion number 503. If they have firm rights, if merchant facilities have firm rights, then they have a demand on the system, a load on the system, and can be assessed costs on that basis. But when they have no firm rights, there's no basis, there's no policy for treating them like zones. And the absence of the word merchant transmission facility in this provision should be respected. There should not be an ongoing cost assessment for these projects, some of which are in Chicago. I mean, some of them are hundreds of miles away and we're still paying for them.
So I take opinion 503 to suggest that if a merchant transmission facility imposes a load, that's sufficient for the merchant transmission facility to be treated as a zone. But it doesn't necessarily mean that the load is necessary. I mean, maybe a merchant transmission facility can be treated as a zone even if it doesn't impose a load. Maybe that question just hasn't been decided by FERC.
Well, I think the language I'm referring to is footnote 84 of opinion 503 and the surrounding text. And there it says that a merchant transmission facility can be assessed costs to the extent of its firm transmission withdrawal rights. And then it says it can avoid these cost assessments if it takes non-firm rights, only non-firm rights. Non-firm rights are essentially the ability to participate in the daily spot market for electricity. It's not a guaranteed or stable source of electricity. And that's the language in opinion number 503 that draws the distinction between firm rights, which can support cost assessments, and non-firm rights.
So you read 503 to say that a merchant transmission facility can only be treated as a zone if it has firm rights. And it forecloses the possibility it could be treated as a zone.
Well, I'm not suggesting that the agency can't come up with a rationale for imposing costs otherwise, but they haven't done that in this case. They have not justified their departure from longstanding policy. The orders under review certainly don't do that. I'm happy to answer any other questions or address questions. Thank you.
Thank you.
Good morning. May it please the court, Susanna Chu for the Federal Energy Regulatory Commission. Your honors are correct that this is not analogous to either the Long Island Power case or the Consolidated Edison decision. We're talking about pre-existing fixed cost allocations that were established and are not subject to cost reallocation. We were talking a little bit about the New Jersey board decision that was part of the Consolidated Edison decision that came out in August 2022. I think it's important to remember that that case involved the solution-based defacts allocations, and that refers to a particular provision in the tariff where the solution-based defects calculation is done, and it uses as a multiplier the firm withdrawal rights of a merchant transmission facility. So that's why the commission found and the court upheld that Hudson and other merchant transmission facilities that had given up their firm rights were not obligated to pay these reliability upgrade costs on a going forward basis. But none of that, none of the firm rights at issue there are relevant to the cost allocations that were at issue in the PJM compliance filing that triggered this litigation. Going back to the language of Section A5, it says that these projects that were selected and planned by PJM in the 2007 to 2013 period are fixed, and they shall not be changed except as specifically set forth herein. Now that is except the specifically set forth herein language does refer to the Con Ed provision at the tariff schedule 12 B11.
What Mr. Townsend's argument that that is about the assignment of costs, not the collection of costs? What do you think about that distinction?
I think that is a false distinction. The discussion of collection in the Long Island Power case is not relevant here. I think the history of that provision, B Romanet 10 B2, shows that Judge Rao, as you were describing earlier, that provision actually addresses situations where a merchant facility does not have its full complement of firm rights. Just as Mr. Townsend was describing, the situation where Hudson had signed an interconnection agreement in 2010 for 320 megawatts of firm rights, but did not yet receive the full complement of those firm rights until 2015. That is the situation that B10, B2 is designed to address. And I think that is shown at opinion 503, paragraph, JA 145. It's paragraph 145, JA 272 to 273. And there's even a PJM compliance filing in response at GAA 281 to 283, showing that that's where provision B10, B2 comes in. It is to address that mechanical situation where a merchant is entitled to receive a certain number of firm rights, but it's not yet in service and doesn't yet have revenue coming in. And so PJM defers the collection of cost until the merchant facility has revenue coming in and is able to pay that amount.
What about Mr. Townsend's argument that this is that the decision here is different from what happened in Con Ed and is contrary to FERC's policies in other instances when someone converts from firm to non-firm rights? Right,
Your Honor. So to the extent that argument was made, this is different from the Con Ed situation because the Con Ed settlement agreement, which was described at the Consolidated Edison decision at 45 Fed 4th 287, that was a 2009 settlement agreement, and it was incorporated into the tariff at section B11.
Is that what they wanted to do here? I mean, here PJM and Hudson agreed, right, to release them from, to prevent the collection or the assignment of those funds going forward. But FERC disagreed.
Well, a couple of things there, Your Honor.
So FERC refused to ratify the agreement that the private parties had come to.
No, there was no agreement between Hudson and PJM. In fact, the compliance filing by PJM actually says that PJM was unsure about what to do with these pre-existing cost allocations in the wake of the Commission's 2017 order that was affirmed in New Jersey Board. At JA 6 through 7, PJM actually says that there are no provisions in Schedule 12 that permit PJM to reallocate cost responsibility for economic projects below 500 kilovolts or cost assignments allocated using violation-based defects. So PJM said that there are no provisions, but they were still making a good faith effort to try to implement the Commission's
They said there were no
orders.
provisions, but they agreed, didn't they, with Hudson
No, they did not,
Position?
Your Honor. No, they proposed to eliminate the cost responsibility,
Well,
but
I mean, is that
they,
agreeing with Hudson?
well, but they said that, we're just making a good faith effort to implement the commission orders. And after that, they did not disagree with the commission orders. They actually appeared as an intervener in support of FERC in this case, although they did not file a brief. So, and I want to say that, so there was not an agreement there, but also,
I don't understand. You said, I mean, they said, we're not going to charge Hudson. And presumably Hudson didn't want to be charged. So it seems like they agreed.
right, okay, yeah, well, Your Honor, I don't mean to be splitting hairs here. It's, PJM said that we're not sure how to implement, but this is our good faith effort to
But
implement.
what they brought forth to FERC was Hudson's proposal to get out from the fixed costs. That's what they put forth in their
Yes.
filing, isn't it?
That is true, Your Honor.
Okay.
I'm just trying to clarify that PJM
Saying
did not
that they
say,
weren't,
we
like,
think,
fully on board, but
I'm
they were actually filing that, but they were filing it with FERC.
that's right, Your Honor. They did file with FERC. They just weren't fully on board. They expressed
I don't
uncertainty.
know what the legal consequence of that is.
I think
We
it's
should
just,
agree that there is no.
I think that's probably right, Your Honor. So just going back to the Con Ed settlement, that provision, the last sentence of B11, it specifically talks about adjusting cost responsibility assignments at the commencement and transmission of, at the commencement and termination of service under the Con Ed service agreements. And in fact, that settlement agreement was before the court in the New Jersey Board and Consolidated Edison cases. The actual settlement agreement is very specific that upon commencement of Con Ed service agreements, the cost responsibility, the cost allocations under Schedule 12 appendix are actually going to be changed to incorporate responsibility for Con Ed. And upon termination, those same allocations will be eliminated to account for Con Ed's termination. I know that is the prior case, but it is in the New Jersey Board Joint Appendix at Volume 4, JA 615. And that does provide the additional background.
Isn't the only difference, though, between those situations whether FERC agreed?
No, I don't think so, Your Honor. I mean, I think there's a difference in that there's this specific settlement agreement that FERC agreed with, yes, but that is incorporated into the tariff. And that is except as specifically specified here, and that falls under the A5 language.
So are you saying that the agreement that PJM and Hudson came to was not the type of settlement that could have been incorporated into the tariff?
I don't think there was
Because
a
is there
settlement
something-
agreement.
But maybe there wasn't a formal settlement? Are you saying it wasn't formal enough? I mean,
It wasn't a
again,
settlement agreement. The Con Ed settlement agreement involved numerous parties. It was Con Ed, PJM, the New Jersey Board. I don't recall all of the parties, but there are numerous parties to that settlement agreement. It was a huge agreement. There was no such settlement agreement here.
but there was some agreement between PJM and Hudson.
Again, I think it was just PJM happened to agree with Hudson's view. They proposed to eliminate the responsibility because they were just trying to implement the commission orders.
And can you respond to the question I asked earlier about the benefits? Because they indicated.
Oh, yes, Your Honor.
Benefits.
So that kind of goes back to the fact that the Section A5 provision, that those allocations are assigned under a different methodology. It doesn't measure present benefits the way the solution-based DFACS does. It actually measures the measures who caused the reliability violation that necessitates the new upgrade. It is described in the commission order, but there's also testimony in the joint appendix, and that is at Joint Appendix 361. And it's a good overview of what makes the violation-based method different from solution-based method. It is also in the order at footnotes 8 and 10 at JA 92.
And you also indicated
oh.
that Hudson should be assigned load regardless of their.
Yes, I'm sorry.
transmission
Yes. I meant to bring out that Hudson is still a customer within PJM. It is still drawing power from the PJM grid. And certainly as to those economic constraint projects, they are still obtaining relief in the form of lower congestion payments, load energy payments. So they are still receiving benefits. They're still part of the PJM system, and they're still bound by these tariff provisions, especially A5, that are fixed. They're fixed, and they were not affected by any of the subsequent developments that were at issue in the prior case.
And I was also asking about whether or not Hudson, you were indicating that they should still be treated as load regardless of their firm withdrawal rights.
That's right, Your Honor. The commission, the commission held that Hudson is still treated as a zone for purposes of these cost allocations, yes.
And how do you determine at what time that occurs?
Well, Your Honor, the timing is not really at issue here because we're talking about a specific set of projects that were previously cost allocated. It's the specific projects that are in the PJM compliance filing. So they were, these projects were assigned to Hudson at a time when they held firm withdrawal rights. So the fact that they later relinquished them doesn't change the fact that they incurred this cost responsibility and they continue to have this cost responsibility as a customer in PJM.
What if Hudson were not a customer anymore? Would they still be on the hook for all these charges?
That's a good question, Your Honor. To be honest, I'm not sure. You mean if Hudson disconnected its line and left PJM altogether? I'm not sure. I mean, in that scenario, it may be, I would suspect the parties would discuss that. And there may be a provision in their interconnection agreements that addresses that.
It seems like the kind of logic of your argument about the violation-based costs would suggest that they would still be on the hook.
I agree, Your Honor, that the logic would say that they probably would still be on the hook, but I don't know if there's a specific provision in their interconnection service agreements or any other agreements they may have that may actually address what happens if they disconnect their line.
There's a line in your brief at page 30, and it's back-to-back sentences, and I just wasn't sure how they fit together. You say, are you there?
The FERC brief, Your Honor, yes.
Yes, your brief. You say that Hudson's firm rights were a proxy for load. But in the next sentence, you say that firm rights have no relationship to allocations for economic projects, which are based on changes in energy load payments. So it sounds like you're saying firm rights are relevant in the first sentence, and then you're saying they're not relevant in the next. But I suspect that's not really what you're trying to say. So tell me what you're really trying to say.
I apologize for any lack of clarity, Your Honor. I mean, I think our reasoning is really in the second sentence, that the economic constraint projects, those are cost allocated. They're allocated, and I may not be able to very accurately describe the specific calculation, but they're calculated once and then they're done. So they calculate forward 15 years the change in the load energy payments that a facility receives as a result of a new upgrade. And then they bring it down to the net present value and allocate those costs among the benefiting parties. So what the commission was saying is that this particular provision just it just relates to the congestion relief benefits and these financial benefits. It just doesn't have to do with the firm rights.
Then how do you square that with the sentence that precedes it where you say that the firm rights are a proxy for load?
I think that's really relevant to, it's a more general point that going back to opinion 503, where the commission had talked about, and that was, in 2009 at a time when merchant facilities that had firm rights were considered unlikely to give them up. So these were considered, their firm rights were used in when a calculation called for the amount of load, they would use the amount of the firm rights. So I'm sorry if those two sentences don't really fit together all that well, but that's.
I'm grateful for the clarification. Can I ask about opinion 503? I think if I were a lay, owner of Hudson or something like that, and I read opinion 503, which was issued at a time when there were no solution-based costs, I think.
Right, that's right, Your Honor.
So it kind of had to be talking about violation-based costs. And I read opinion 503 and it sounds like, I can avoid these costs if I opt out of my firm rights. And in particular, it says the cost allocation provisions in Schedule 12 provide that a merchant transmission owner does not own firm rights, does not receive cost responsibility assignments for RTEP projects. So, why would I have been wrong to read that and think, okay, if I want out of these cost responsibility assignments, I just need to opt out of my firm rights?
Well, going back to the initial choice as to whether to opt in for firm rights or not opt in, if you do not opt in at all, then there would be no cost assignments. What happened here is that once PJM shifted over to the new solution-based DFACS method, the PJM implemented a firm cutoff, and that's section A5, that as of February 1st, 2013, all of the violation-based costs are fixed and they shall not be changed. And it's important to remember the violation-based costs, they're allocated based on, they're like a snapshot in time. It's who has caused the need for a specific reliability upgrade. And it's explained, I believe in the testimony I cited earlier, JA 361, that the violation-based method cannot be rerun. It's not like solution-based DFACS, which is done every year.
Con Ed's violation-based costs were reallocated.
Right, but they weren't, right, they were not recalculated, shall I say. Yes, they were, when Con Ed terminated, yes, their allocations were just eliminated and the remaining costs were reassigned.
The same thing could happen here.
Yes, as a practical matter, that is possible, but the commission held that wasn't appropriate in this situation because there was no settlement like the 2009 Con Ed settlement and no provision like the Con Ed provision.
What if I think your explanation of the conflict between what happened here and opinion 503 is persuasive, but I don't see that explanation in FERC's order?
Well, I think it is, Your Honor. I think the order does refer to the Con Ed situation and the Con Ed provision. It's that paragraph 24.
On opinion 503 is pretty cursory.
Right. Well, 503 is really the backdrop to all of this. The commission, of course, is not addressing these issues in a vacuum. The commission has been navigating these issues for over a decade, or it's been a very long time. So, opinion 503, that's first. That is, I believe, front and center in the commission's mind. I believe it is cited, And at the rehearing order at paragraph 24, I think that's where the reasoning is. I think it is there, Your Honor. I think it's discernible from the order.
Well, and then I think this will be my last question, but if it's as cursory as I think the 503 discussion was, it's at least longer than the cost causation analysis, which I think is not there at all. And I think maybe your argument is, well, it didn't need to be there because we've done all of this before. This is not a different situation, right?
That's right, Your Honor.
But if it's not a different situation from, for example, opinion 503, then it seems like, fine, let's apply the general rule from opinion 503, which says if you don't have firm rights, you don't pay violation-based costs.
I'm sorry, Your Honor, if I lost you there. I think that you're talking about the A5 projects here, right?
I'm talking about the violation-based
violation-based cost.
And I'm saying there's no cost causation analysis in FERC's order. And that would probably be okay if FERC was just rerunning stuff it had done before. But I think your point is that, no, FERC's not rerunning stuff it did before. FERC is doing something different here. This is a different scenario than opinion 503. In which case, it seems like you probably needed some cost causation discussion.
Okay, I'm sorry.
It's not a different scenario than 503. It seems like you should have applied 503's general rule that if you don't have firm rights, you don't pay violation-based costs.
I think I understand, Your Honor. The commission is relying on those violation-based cost assessments that were done in 2007 to 2013. I mean, they were a just and reasonable allocation and use of, the prevailing method at the time. So the commission did not feel it had to rerun the cost.
I get that. So that's fine. But then why not, in that case, apply what FERC said at the time, which is if you don't have firm rights, you don't pay violation-based costs.
Right. But I think, Your Honor, it's because the Hudson had the firm rights at the time they were allocated, and we're just applying the tariff now. We're applying Section A5, which says that those costs are fixed and they shall not be changed unless there is a specific exclusion from these particular allocations. Again, the commission here, is relying on the fact that it's not required to consider the cost allocation rules on a project by project basis. I think that was in the court's Long Island Power decision, 27 Fed 4th at 715. That would unravel the whole framework of these ex-ante tariffs. So the commission, this is just like the New Jersey board case where the result is it's the result of a combined set of permissible circumstances that does not render any of these rates unjust and unreasonable.
Thank you. There's two.
Thank you, Your Honor.
I'm John Longstreth for PPL. We're one of the transmission owners in PJM. Let me start at the end because to Judge Walker's question, because I think it's absolutely consistent what's going on. What it says in Order 503 is, if you have firm rights, you get assigned these costs. That's exactly what happened. Because they had firm rights, those rights were causing a violation, and under violation-based defects, they had to pay those. Now, if you're reading it and saying, okay, I don't have firm rights, they could have done that in 2010, they could have done that in 2011, they could have done that in 2012. Suppose in 2012, they decide to give up their firm rights. They're not responsible for any violation-based defects after that. But for the rights they had at the time those reliability projects were planned, violation-based defects said, you've got to pay those costs, and you can't get out of them later the way you can with solution-based defects. I think it's absolutely consistent with 503.
Let me ask about that. It seems like that argument relies on a distinction between allocating the costs and collecting the costs. And it's fine if you think that that's an important line to draw.
Right.
But that's going to cut against you when we get to B10 because,
I don't think so.
no?
No, I don't think so because B10 is just a different situation. I think when Judge Rao suggested, and I understand, FERC shorthanded a little bit and we did a little bit in our brief. We just don't think B10 really has anything to do with the situation, for example, you had in LIPA. In LIPA, it was very clear that you had to be collecting at the time you had the firm rights. Here, the firm rights, and again, remember for violation-based defects, when you have the firm rights, PJM is planning ahead. So in 2010, 2011, they're planning for what's going to happen in 2015. And they're saying, if you cause that, you cause that. We're building it for you. If you decide 5, 6, 7 years later, you want to get out of it, we built it for you back then. And that was the rule. That's the rule that applies. So that was the rule. That was the rule. And we talked about cost causation. Everybody understood that was the rule. I don't understand anybody's ever brought a cost causation case against violation-based defects. Cause is right in the violation. You are causing the problem. We are building this for you based on the rights you tell us that you're going to have. And that's another issue too, when they talked about we didn't have firm rights and I think even FERC counsel talked about did the full complement of rights. They had full rights at 2010, 2011, 2012. They came and said, we're going to have these 320 kilowatts and you're going to have to build for them. Okay. PJM doesn't know at the time they're building that and or ordering that to be built and planning it, that 5, 6, 7 years from now, they're going to give up their rights. They have to assume they have those rights going forward. So they're planning the project for those rights at the time that they have. So they absolutely did have the rights. It's just that they didn't exercise the rights until the facilities were actually built in 2015, 2016. And that's what happened here. It's a deferred payment. So again, that's completely different from the LIPA case. In the LIPA case, the problem was that even though the costs were accruing and it didn't necessarily make a lot of sense that, they're going to be accruing costs, but we can't collect them until FERC gets around to ruling on it. The problem was that's what the tariff said. Here, it's absolutely not what the tariff says. The tariff says not that you have to be collecting at the time that they have firm rights, but that when we come to calculate your payments, we basically look to see the rights, and it's, what's the exact language? Because he skipped over it, that have been awarded. We look at the rights that have been awarded. It's looking back language in that B10, B Roman 10-2 language, completely different from the LIPA case. Okay,
Yeah.
thank you very much.
Thank you. A few minutes on the call.
Thank you. So much of this case can be resolved with 3 words: collection, actual, and assignment. There cannot be collection without actual firm rights. The provision that FERC relies on and that PPL rely on is about assignment of cost responsibility, different from collection. And the argument has been made, well, LIPA is a different case. I mean, we don't need, LIPA addressed the word collect and said it was unambiguous, but even if the LIPA decision had never issued, the plain text of the statute, the plain English meaning of the word collection supports our interpretation. As for the costs that we were not in service until 2013. And so at that time, we paid $335 million for all violations that we could conceivably cause in order to connect to the PJM grid. Those caused violations have been paid for. We walked away from that investment. And I want to stress that that was not an easy choice. That was an enormous investment that we had to leave on the table to stop the bleeding from these additional assessments, these additional collections. And
So as a practical matter, if we agree with FERC, would Hudson want to sort of go back to having firm rights in the grid that's going to be paying for them?
Certainly not under the conditions that prevailed when we had them during that period. It was an untenable position where we were just socked with massive costs, $600 million some costs for the Bergen-Linden corridor project alone. It was
But most of those were
tenable.
solution-based.
I beg your pardon?
Most of those were solution-based costs, not these violations.
Most of them, to be sure, but we have 136 million in violation-based costs here as well. And to go back to your points about opinion 503, the understanding was when that issued that the only methodology was violation-based defects at that time, the so-called fixed once and done allocation. And yet the opinion says, it says in so many terms that the merchant facility can take non-firm rights and avoid those charges. That's exactly what we did.
Can I ask you, oh, no, please, Judge.
How does that 136 million that you mentioned compare to the actual benefit you received?
So first of all, the benefits that we received from firm rights, we paid for in the time that we had firm rights. We're not asking for any sort of a refund. At this point, we only have non-firm rights, and that means an incidental benefit to participate in the daily spot market for electricity. That's not a basis for allocating costs. Never has been. The Seventh Circuit said in the Illinois Commerce case, we mustn't allow the incidental benefits tail to wag the primary benefits dog. Everyone who is connected to the grid can be said to be deriving some incidental benefit from any improvement anywhere in the grid. And yet they're not charged. They're not charged. Only the metric for charging a merchant transmission facility is firm transmission withdrawal rights. And FERC established that in opinion number 503. I'm over my time. I'm happy to answer any other questions.
Do you think that any of the arguments that FERC or the intervener made today are kind of precluded because FERC did not make them in its order?
Yes, we heard.
Which ones?
We heard today for the first time a theory for what B10, B2 means. And I think it was a reference to Joint Appendix page 275. That's not a theory that's reflected in the orders under review. It would be barred by Chenery.
Thank you. Case submitted.
starting. Oral argument is about to start. Tied up for the next 45 to 60 minutes. Mute. Mute.
Stand, please. This honorable court is again in session. Case number 22-1337 et al. International Dark Sky Association, Inc. Appellant versus Federal Communications Commission. Mr. Mudd for the appellant International Dark Sky Association, Inc. Mr. Michalopoulos for the appellant Dish Network Corporation. Mr. Carr for the appellee, issues raised by Dish Network. Ms. May for the appellee, issues raised by International Dark Sky. Mr. Shaw for the intervener.
Mr. Mudd, whenever ready.
Thank you. Good morning, Your Honors. May it please the court. My name is Charles Lee Mudd Jr. on behalf of the Appellant International Dark Sky Association, or Dark Sky, and with the court's permission, I'd like to reserve 2 minutes for rebuttal. Not too long ago, before my father passed away, he and I spoke about how growing up in the country in Kentucky, he could walk outside when doing the chores in the morning and see the Milky Way. Lost now, even in the Kentucky country, you're not really able to see the Milky Way. And that kind of reminds me similarly to an analogous situation with young students in Chicago that have never really ventured to the suburbs or beyond. And when they do, on exploratory aspects, they're amazed at a different world that they see in the night sky with a number of stars. Now, both of those situations involve ground-based light pollution. And on that issue, the society, we happen to be in efforts to remediate. But here too, we're focused on the effects on the ground, the Earth, here terrestrially. Yes, we're at issue with satellites, and yes, we're talking to some extent or a large extent about solar reflectivity of the satellites, but let's not forget that Earth terrestrially is central. The satellites are developed and planned here on Earth. They're manufactured here on Earth. They're launched from Earth, and for some, there's re-entry into Earth's atmosphere. They're operated from Earth, and most importantly for today, the effects that we're talking about are here on Earth terrestrially. So we're not.
Mr. Mudd, maybe we could start out by talking about standing for your organization. I'd first have some questions on redressability. So, for instance, if the license here were to be set aside, what would be the practical consequence of that for the harms alleged here? Because satellites, the FCC here is licensing radio frequencies and transmissions. It's not regulating the actual launching of the satellites into space. I mean, that's the FAA and I assume other agencies as well. So can you speak to redressability here?
Yes, and in doing so, I'll focus on 2 points. First, to your latter comment, the FCC, for better or for worse, has really stepped in to be the sheriff and regulate outer space activities in that regard. For example, mitigating space debris and the satellites and requiring requirements on that. The FAA is the launch and reentry. There's also NOAA for Earth observation, but in terms of the operations of the satellites during their lifespan, that is the FCC. And so this falls clearly in their purview. But to your first point, the redressability and what is the effect of reversing the license, it's compliance with the law. You know, NEPA and the FCC's own regulations clearly state, and even if with respect to the categorical exclusion, though it's an antiquated assessment that the FCC has made of its activities, but even with that categorical exclusion, its own regulations point out that if a third party submits evidence and contends that there are significant environmental effects,
That
and
doesn't
the
go to,
FCC,
that doesn't go to standing, though. It doesn't go to the question of redressability.
so you're talking about our standing with respect to how
Your
we're
standing,
involved?
right, which we
Right,
have to
okay.
assure ourselves that you have before we reach the merits of your claims.
Sure, and this court has previously addressed another case involving a SpaceX application in the FCC decision and found there that organizations did not have standing, and clearly those organizations in that case are distinctly different than the International Dark Sky. And if there is the environmental assessment required and they go through that process, the IDA benefits by having, ideally, if there are significant effects, which we contend there are, that the FCC will address those and look at those and come up with orders that balance all of the interests. The failure to do that is we might end up having a diminished dark sky. 7,500, even the reduced number of satellites, doubles the amount of active satellites worldwide. And when you talk about a broader aspect of the effects on the night sky, astronomy, the cultural effects, and so forth, that's significant. And that's where our standing comes in, because we have a vested interest in making sure that the satellites that are launched and the applications for licenses are compliant with law, where there are.
So is it your contention that if the FCC were to make a different decision, that these satellites would not be launched? Because I think there has to be some sort of, we have relaxed redressability in our NEPA cases, but it's not, there still has to be some link between the NEPA analysis and the harm that's being alleged.
Right, but I would also contend that redressability does not mean that a party has to guarantee that everything will be resolved in its favor. We just want compliance.
I didn't say
with
that.
law.
There still has to be some link, though. There has to be some causal connection.
And I would argue that
between the NEPA procedure and the harms that you want redressed.
Right. And I would argue that the FCC's own regulations provide that redressability and that nexus. It states if an interested person alleges that a particular action otherwise categorically excluded will have a significant environmental effect, the person shall electronically submit, etc. And we have a vested interest.
Mr. Mudd, the FCC doesn't have the standing requirement of an Article 3 court. They welcome all comers and comments, including for people who would not have standing in court. So we're still waiting for your focus on redressability for you or your members and organizations.
Well, all right. So the redressability, if there are significant effects and there were additional mitigating aspects that the FCC would have to impose on SpaceX, then we are benefiting by the continued existence of a dark sky as we know it today. And if those
Would you, with
requirements-
respect to the standing argument, though, distinguish standing with respect to light pollution claims versus the aluminum deposits versus the launch emissions? Because I feel like they're blending everything and there might be distinctions at least there.
Well, with respect to the alumina itself can diffuse the night sky and have an effect on the overall brightness or darkness of the night sky. And so I understand, and that the other parties have argued that the atmospheric effects is something completely outside the purview of the IDA by its mission. I disagree in principle, and I think that that would be a very narrow reading of the contours of what the IDA is advocating and interested in, because all these issues are related. But I don't think we need to even address that, because the alumina does have and can have a significant effect as it increases on diffusing the nights or diffusing the atmosphere such that the dark sky becomes lighter. So there
So
is
the agency relied upon I guess it was the European Space Agency, wasn't it, saying that there was no significant effect?
the actual, with all due respect, Your Honor, I believe that the ESA reports contended that there was needing to be more studies and that there wasn't a definitive conclusion that could be made. And I would argue too,
Okay, but they could not at this time, or when they did the study, make a finding of a significant effect.
but that goes to our argument that we don't need to show certainty. We just need to show that or the FCC decides that there may be significant effects. And we've submitted, as other parties have, sufficient evidence and testimony that there are significant effects. And even if the SEC doesn't necessarily agree that for sure there are, the argument has been made and the evidence introduced that it's hard to ignore and not conclude that there may be significant effects. And that is the May standard. And that's all that we necessarily need to show here. And that's all that needs to be done to require an environmental assessment. And
But
that's
the May standard, as you call it in your briefs, is, I mean, the FCC makes the determination. It doesn't say that if comments are put forward suggesting that this may have an effect, that they have to order an environmental assessment. It's a determination that has to be made by the commission.
the commission needs to review the petition and consider the environmental concerns. And if it determines that it may have a significant environmental impact, require the applicant to prepare an EA. But that's where we bring in the APA, because you are correct that it is its determination, but it can't just dismiss or facially address the issue and not substantively consider all the aspects brought before it. And we contend that's what happened. It's one thing to put in a lot of words and recitate, which it did, the number of parties and evidence introduced by Dark Sky as well as others, and go through and then say, for example, Judge Ginsburg, in reference to the ESA, say, well, there's this report out here that suggests that there's no determination right now that there are significant effects. We're done. But I would argue that that's not the reasoned analysis that the APA requires. And it's really an arbitrary and capricious treatment of these particular issues to reach the conclusion. So yes, it is the FCC's conclusion and decision, but the APA requires something more than just a recitation of the arguments and saying, we decide this way. It needs to give that reasoned analysis. I see that my time has expired, and I'll address any other questions that you may have. Otherwise, I'll conclude on my rebuttal.
I do have one more question. I mean, do you think that we need to decide here whether NEPA applies in space?
I don't think that needs to be decided. I personally, I do. I mean, we do, and the IDA does, but I don't think that that's necessary to be decided, because as I began my argument, the focus here are the effects on Earth terrestrially. So and that goes to the fact that these are satellites that are manufactured, operated, controlled from Earth, and so forth. And the effects that we're talking about, particularly with respect to the night sky, those are effects that we feel here on Earth terrestrially.
Any further questions?
No.
Thank you, Mr. Meadow.
Thank you, Your Honors.
Your Honors, may I approach?
I think I've ever had exhibits, yeah.
The demonstrable.
Go ahead.
And I think Judge Ginsburg has his own. May it please the court, Pantelis Mikalopoulos for this. I would like to reserve 1 minute of my time. My colleague, Andrew McLaughlin, will be helping with handling the exhibits. The FCC and SpaceX defend the order below by resorting to ideas invented after the fact, allegations of harmless error, and a claim made by SpaceX about a favorable finding of the foreign body, the ITU, that shows everything that is wrong with this private subdelegation because it is the wrong finding for the wrong system. The FCC disregarded this as evidence that SpaceX's generation system would flunk the limits. And to be clear, we're not questioning the ITU limits themselves or their incorporation by the FCC. But we applied the ITU method, we applied the ITU software without any modification. Now the FCC says that there were reasons to doubt are showing, but no such reasons were expressed in the order. It's the brief's invention. And the brief says, well, there had been no reports of harmful interference from the first generation system, which had been lower power. But finding harmful interference in this case is like a game of whack-a-mole when the moles are invisible. This, and this is our first exhibit, is what the SpaceX system looks like. We don't know where the customers are.
And analyzed SpaceX's submission as 18 separate submissions, right? Whereas the ITU analysis would have treated them as one.
Yeah, we rebutted their effort to split the system in 18, and we combined the 18 into one. Then the FCC required SpaceX to submit a combined showing. We analyzed that combined showing as well. So it was not we who split it 18 ways, it was SpaceX. So we don't know where the customers are. We don't know where the satellites are. We don't know whom to knock on the door of among our subscribers and say, tomorrow you may lose your football game and please give us a call. So the FCC ignored our evidence only on the ground that it is the ITU's job to look into compliance. But the FCC knew how to look into compliance when it wanted to. The first showing, and that goes to your question, Judge Rao, the first showing by SpaceX of compliance was made in the record. And what did they do? They split the system 18 ways in order to shoehorn it in the limits. That's what they did. And we said that this is like me claiming to break the world record for 100 meters by running from here, I guess to where Judge Ginsburg is on the screen, in 9 seconds. And we said that if you put together, we put together the 18 constellations, and if you put them together, you vastly exceed the power limits. But all of this was overtaken by events outside of the record, because the FCC had concluded that this first showing of SpaceX was inadequate. And we know that SpaceX and says you need to submit a second showing. So before washing its hands of compliance, the FCC had kept its hands in the soup, or at least tasted the soup, but in a kitchen closed to the public.
So why though is this not a collateral attack on the FCC's regulation that decided to use the ITU standards?
So
That was already established in a rulemaking. You know, the FCC made a determination that they would rely on the ITU standards. So why is this not a collateral attack on that, which would not be permitted in this licensing?
So for two reasons. First of all, we're not questioning the standards themselves. We're not questioning the incorporation of those standards by the ITU. We're questioning the disregard for our evidence that the standards are met. Second, and this was the Viasat case, what Viasat faulted DISH for doing was saying the methodology of the ITU needs to be improved. We are not saying that. We're saying apply your rules. Apply the methodology. The rule says ITU approved software. We applied the ITU approved software without any change. So we're saying to the FCC, put that in the record. The FCC says, no, we will not let you evaluate this new showing. This was the combined system showing that SpaceX outside there. And the FCC said no, on the astonishing ground that it didn't consider the substance of the submission it requested. And the FCC says, well, in its own very defensive words, we requested it for the facilitation of preparation for coordination. But the problem is this is a smokescreen because the substance of the coordination is the same as the substance of the proceeding.
But step, I mean, SpaceX merely has to certify that it would pass the ITU standards.
Yes, this is the first step.
So looking at the certification doesn't require the commission to actually look at the ITU, you know, running the software.
Well,
I mean, isn't that right? I mean, that's the sort of the way and you say you're not challenging the FCC.
We're not challenging the FCC. The agency has in front of it evidence that something is wrong. SpaceX had to split the system 18 ways to make it fit. And the FCC looked at this and said, well, something is wrong with that. So it didn't wash its hands right then, right? It knew enough to assess compliance a little bit. But when such evidence is there, you don't blind yourself and say ITU, ITU. The rule only says that the ITU finding will be a condition. It doesn't say the FCC will do nothing more and will blind itself to evidence to the contrary. And so the substance of coordination, because the FCC says we only requested the submission for the facilitation of coordination, the substance of coordination is the same as the substance of this proceeding.
Isn't the FCC's regulation that suggests it can look behind the certification or evaluate anything at that stage?
There's nothing.
It's just suggesting that just sort of as a matter of reasonableness.
Yeah, as a matter of reasonableness, when they have evidence that something may be strained here, that you need to split your system 18 ways to make it fit, they looked at this, and they should have looked at this, and they should have done more. There's nothing in the rule, which should be respected, but there's nothing in the rule that prohibits them from doing that. So they're saying we're not putting in the public record on a separate ex parte issue. We're not putting it in the public record because we only request for coordination, but the substance of coordination is about power limits. It's the same substance. In other words, in coordination.
Counsel, if the FCC looked at the evidence that you're proposing and said this is evidence of that it supports compliance, it would still, I believe, have to send the matter to the ITU, and the ITU would make its own determination. Is that correct?
In that case, yes. If the
now suppose the FCC looked at it and said this does not comply with the ITU, then what, it would not send it to the ITU? Is that what you're saying?
Well, since the FCC represents SpaceX in the ITU process, that's what coordination is. The FCC would have to call the ITU, file a submission and say, this system meets the limits. If, based on our evidence of the infirmities of the second showing, the FCC was not convinced, it would have to make a different submission to the ITU. Either go back to SpaceX and get a different showing, or say to the ITU, we have reservations about this. So that's what would happen.
We have reservations, and then the ITU would perform an independent determination, correct?
Yeah, and
So ultimately, whatever the FCC thinks, the ITU is going to be dispositive. And the purpose of the rule and the scheme here is to get the service into the public wheel and to avoid delay. Isn't that correct?
well, Your Honor, you mentioned that the ITU's finding would be dispositive. First of all, one hopes that the ITU would take into account the FCC's views, even though the FCC cannot tell the ITU what to do. But the dispositiveness of the ITU finding is one of the major problems we have with subdelegation. But
Well,
as
that's the rule you say you're not attacking.
no, not Your Honor. We are attacking the
No, I mean,
subdelegation
you're
as
actually
applied
asking,
here.
seems to me you're actually asking the FCC to depart from its rules.
No, we are attacking subdelegation as the rule has been applied here. We don't have any problem with the rule per se. But if the rule were to mean, which we don't believe it means, that the FCC need do nothing more, beyond punting to the ITU, then that's an improper subdelegation. And as far
How is your subdelegation claim an as-applied challenge? I mean, if the FCC had impermissibly subdelegated to the ITU, wouldn't that be a facial challenge? I mean, that would be a challenge. That's a challenge to the regulation, on its face. Like, you can't have an impermissible how do you have an impermissible subdelegation just for one party as applied? I don't.
conditions for proper subdelegation, reasonable condition, fact-finding, advice-giving, the agency has the final say. If the rule of the FCC, which we respect, were interpreted as we think it should be interpreted, so as to give the FCC the final say, then this would be permissible. If the agency does not have the final say, this is unconstitutional. And that's the respect in which this is a challenge to the rule here, if it's applied to not give the agency the final say. And so the FCC argues harmless error, because we had all of one business day, not before the order, before the deadline on reconsideration, to look at the new showing. And
Ask you a question about this, whether DISH forfeited its argument on subdelegation, because the FCC does discuss the subdelegation issue in its order, but at least in the record before us, where did DISH raise that argument before the FCC?
oh, we made the argument, and I'll get you the side. It was raised in paragraph 28 in response to our raising the issue. So we very specifically raised the subdelegation issue.
Because the
With it.
FCC doesn't cite to anything in its.
Well, it should have. Yeah.
Okay, so if you could give me that site.
Yeah, of course. And so, but the FCC had already said that whatever this says will not affect our decision, because the showing is sort of immaterial after having requested it. Now, the harmfulness of the error is shown when we were finally able to analyze the second showing. That was after the order, months after. That was in March of 2023. And what had happened was SpaceX had resorted to another trick. It had used a different exclusion angle than used in the ITU software. And the SpaceX tries to demote this to a hyper-technical matter, but it has a very simple effect. The calculation includes only power from those satellites that transmit hardly any power at all. So it's very easy then to show that the system does not exceed the power limits. And SpaceX trumpets 3 times this famous favorable finding of the ITU in its brief. It says, it ends all speculation, it makes the issue moot. It's not for the second generation system. This is not accurate. This is a favorable finding for a system filed by SpaceX back on October 7th, 2019. And you can find that in Joint Appendix 264.
I see. Questions?
No.
Ginsburg?
One
No,
moment. Thank you.
May it please the court. My name is James Carr. I represent the Federal Communications Commission. I will be addressing the issues raised by Dish Network, and my colleague, Rachel Proctor-May, will be addressing the issues raised by the International Dark Sky Association. So let's start with first principles here. This court has long recognized, as it's stated in the Viasat opinion, that the FCC must adhere to its own rules and regulations, and that's precisely what the FCC did here. Judge Rao, as you pointed out, under the FCC's rules, the first step for an applicant for authorization of a satellite system like SpaceX's is to certify that that system will comply with the ITU's rules using the ITU software. SpaceX did exactly that. SpaceX was not required under the rules to submit any sort of technical analysis to the FCC, nor does the FCC, as it has made clear when it first adopted the rules, the FCC itself does not engage in a technical analysis, and it doesn't look at if a third party, such as Dish, were to present technical analysis, it doesn't look at any of that either. It treats the certification as binding. Of course, the certification remains subject to ITU verification later, and which is exactly what happened in Viasat. SpaceX certified, the FCC accepted the certification, and at some later point, the ITU confirmed that SpaceX had accurately certified.
What about those cases indicating that FCC can't just rubber stamp, these issues with respect to the certification? In other words, self-certification can be okay standing alone, but when there's a challenge substantively to it that is not intended to cause delay or anything of that nature, why wouldn't the FCC address it even if it discounted it?
Well, Your Honor, again, going to the rule, if the FCC were to require some SpaceX to grapple with Dish's study, that would be imposing additional requirements on SpaceX, which are beyond the scope of our rules. I will note, and Dish makes much of a particular case, Animal Legal Defense Fund, where it points out that the court in a particular circumstance said that it was arbitrary for the agency in that case to rely on certification. But that was a very unique case. As Judge Edwards described it, it was a smoking gun case where the agency itself had direct knowledge that the facts certified by the applicant simply were not true. It knew for a fact that the certification was false.
So if the FCC had information like that, would it have to look behind SpaceX's certification?
I think if it actually had certification or had knowledge that SpaceX was making a misrepresentation, it would have to. But again, that
network's submission, not that type of smoking.
Well, here's the difference. In Animal Legal Defense Fund, it was the agency's own experience with the regulated entity. In that case, the agency had already engaged in a number of enforcement actions against the particular applicant. So the agency knew from its own experience that
an agency could get knowledge either from its own experience or perhaps from a third party. So why is their submission not adequate to cause the FCC to look behind the certification?
I think, again, Your Honor, if you look to past cases. And this court has recognized in the Global Crossing case, for example, that the commission has relied on certifications in the past, and that's a permissible exercise of its rulemaking discretion. As long as...
But I'm just saying, why is it reasonable if there's information presented to the agency that the certification may be faulty or misleading? So in what circumstances would the agency have to look at that or take it seriously?
I think the Animal Legal Defense Fund case gives you a circumstance. That would be where the agency knows. It may well be, Your Honor. If it's simply enough for a third party to present evidence that suggests that there's some problem, that ultimately defeats the purpose of certification. The certification process is designed to prevent long delays and to move the process along. Now, certification is only reasonable if there is a backup, if there is subsequent verification, which we have here. The ITU finding that is required by the commission provides backup. So ultimately, if DISH is correct that there is some sort of problem with SpaceX's certification, the ITU will make that finding, will make an unfavorable finding, and SpaceX, assuming it has commenced operations before the ITU finding, proceeds at its own risk. And if there is an unfavorable finding, SpaceX is going to have to reconfigure its operations.
A practical question. I mean, so the FCC has to determine whether a satellite would have unacceptable interference, right? That's the standard.
That's right, Your Honor.
And under the regulation, rely on ITU to make that fine. You rely on the ITU standards.
And the commission incorporated by reference the ITU rules. It made an independent determination that compliance with those rules would satisfy the obligation not to cause harmful interference.
So does the FCC do anything else? Like once it gets the ITU's finding that a particular applicant meets their standards, is there anything else that the FCC does in its process to determine whether there would be unacceptable interference?
No, at that point, there wouldn't be anything the commission would do. Although keep in mind, and Judge Katz's in the Viasat opinion made this point, which is that if there were evidence of actual interference, regardless of an ITU finding, if there were evidence of actual harmful interference, the commission would take action to eliminate that.
But in the actual process, the FCC doesn't take any further action once it has an ITU finding.
That's right. And the reason, Your Honor, is that when the commission adopted these rules, it explained that once it gets the certification, if the commission staff were to do the sort of analysis using the ITU software and confirming the certification, that would essentially duplicate the ITU's process, because we know that the ITU is going to have to do that process to ensure international coordination.
I'll just ask you one other factual question I didn't see.
Yes.
Yeah, I missed this. Do we have any kind of treaty obligation to follow the ITU, or is there any other kind of formal relationship that the United States has with ITU? Because I mean, there are other cases in which, there's an international standard, we've joined it by treaty, something like that. Is there anything of that nature here? Does the US participate in the ITU standard setting? I'm just curious.
My understanding is that yes, there is a treaty or agreement where the FC or the United States participates in the ITU process.
So there's some like executive agreement? Is that a formal agreement?
I don't know for sure, Your Honor. I do know that typically the way this ITU process works is that different nations serve as member countries, and they provide when a company comes to them with an application, the FCC.
It's been useful for the FCC to mention that. I mean, in terms of whether it's implementing other international agreements that the federal government has.
I understand, Your Honor. I believe that our intervener made some reference to the treaty obligations of the United States, and I apologize that the commission didn't mention that. But the way this works is that the FCC, as the member administration, would pass on to the ITU whatever filings SpaceX made to the FCC. So it serves as a conduit, which again goes to this point about the combined file, which has been a source of great confusion in this case. The commission requested the combined file of SpaceX because it wanted to make sure that the ITU had a complete record when it examined the question of whether or not the SpaceX was in compliance. For that reason, the commission did not actually rely on the substance of that file at all. It did not look at the substance. It simply regarded when it approved this application. It relied on the certification. It didn't consider the substance, and therefore the ex parte rules, the FCC's ex parte rules did not apply because the filing did not go to the merits or the outcome of the proceeding, did not influence the commission's judgment in any way, and therefore there was no need for the commission to make that available for someone else to comment. And as we've said before, the notion of third-party comments on this going to interference analysis is inconsistent with the way the rule is structured. The first step is we accept the certification once a party has certified, and we have reason to believe that the certification is accurate because, among other things, parties that certify, if they are wrong, are subject to severe penalties. For one thing, SpaceX would have to reconfigure its system. For another thing, there could be fines and penalties for inaccurate certifications. Well, we would find out from the ITU. The ITU will confirm the certification. So if the ITU makes an unfavorable finding, then that would mean that that the certification was incorrect. That would require SpaceX to alter its operations to come into compliance with the limits. And it could conceivably result in further penalties. So
you're
from the
suggesting that
commission.
FCC is not involved in that process of looking at substantive information that actually challenges that certification process? That's supposed to go through ITU.
That will go through the ITU under the way the rule is structured. That's right, Your Honor, that the ITU will take the data files that have been submitted by the commission on behalf of the applicant, SpaceX. It will use the software and apply the data files, apply the software to the data files and make a determination as to whether or not it complies.
And what's actually involved in ITU running the software? Because we have this issue about should we evaluate this information singly or jointly?
Well, the commission itself made a determination that it conditioned this authorization on SpaceX obtaining a finding from the ITU that explicitly states that the ITU has considered the joint effect of SpaceX's operations. And that's because I think the commission was concerned, and it wanted to clarify this, that the comprehensive effect of the satellite system was going to be taken into account, not that you were looking at 18 separate filings. Now, the commission addressed, I believe it was in paragraph 31 of the joint of the order, the argument that Dish made that somehow the 18 separate filings were an attempt by SpaceX to manipulate the system. SpaceX explained, and the commission accepted the explanation, that the ITU staff itself had suggested that sort of segmentation. And the reason for that was, again, this goes to a different analysis. This goes to power flux density as opposed to equivalent power flux density. When the ITU examines that particular issue, which involves the potential for interference to terrestrial operations, it needs to have the file segmented in order to examine that.
Well,
That's what, and I'm sorry, go ahead, Your Honor.
Help me out with what
Yes.
potentially could be a conflict in the order, because it says FCC order requires SpaceX to get a finding from the ITU that expressly indicates that the ITU has considered the joint effect of SpaceX's
Yes.
ITU filings.
Yes.
But then the order states, we also find that SpaceX's segmentation of its system into 18 separate ITU filings is reasonable.
And for just the reason I was explaining, Your Honor, that SpaceX consulted with ITU staff, and ITU staff told SpaceX that it preferred segmentation precisely for the analysis of the separate question of power flux density. But as to power flux density, I'm sorry, Your Honor, go ahead.
I guess it wanted to see the data both ways, sliced into 18 and then combination.
I think that's right, although I don't know that the ITU made that entirely clear, and that's part of the reason why the commission asked as a follow-on for SpaceX to submit a combined filing that could then be run through the system that would confirm that the joint effect of the system would be in compliance with the relevant power limits.
But then help me with the
Yes.
subdelegation issue, like who's actually making the decision about joint effect versus?
Sure, Your Honor.
Okay.
Remember, when we're talking about subdelegation, we're talking about subdelegation of regulatory authority here. The FCC exercised its regulatory authority in the first instance when it made an independent judgment to incorporate by reference into its rules the ITU's power limits. And it made a determination that compliance with those power limits would satisfy the obligation not to cause unacceptable interference. Under this process, it then relies on input from the ITU, which this court described in the 2004 US Telecom case as legitimate outside party input in two respects. First, the ITU finding is a reasonable condition on the authorization, because after all, the whole point is we want to confirm that these folks are in compliance with the power limits so that they won't cause harmful interference. The ITU finding does that. So it's a reasonable condition on the authorization. Second, we would argue that the ITU's information provided to the commission amounts to fact gathering. It's factual information. It addresses the factual question of, is SpaceX in compliance with the ITU's power limits or not? And under this court's case law, under the US Telecom case, that is an acceptable use of outside party input, and it is not an improper subdelegation.
What was the point of directing SpaceX to release the information after the fact?
Your Honor, the disclosure requirement was a condition that the commission adopted as part of its decision to grant the partial waiver of the rules to allow SpaceX to go ahead and operate before it obtained an ITU finding. It's my understanding that was the point of that was to provide transparency to outside parties. They could get the information, they could run it using the software and make a determination for themselves as to whether or not it satisfied. I think it was meant to put people's minds at ease. Now Dish took the information, ran it through the software, but it looked at SpaceX's inputs and it said, well, SpaceX got this wrong. So it altered SpaceX's inputs. I don't necessarily think that Dish disagrees with the notion that if the ITU were to take SpaceX's inputs as is, ran them through the software, they would show compliance. Dish has a quarrel with SpaceX about how it put together the inputs, and
but be that as it may, suppose they look at the data, or some other party looks at the data and says, well, this does not show compliance. Can they present an argument to the ITU?
They cannot present an argument to the ITU, but what they can do, and what Dish has done in its March 6th letter, March 6, 2023 letter, which is in the joint appendix, Dish went to the commission and said, FCC, we have evidence that this is out of compliance, that SpaceX hasn't complied with the ITU rules in putting together its input, and you, FCC, as the relevant administration, should make clear to the ITU that this is the problem. So they would have the opportunity to come to the FCC and ask the FCC to go to the ITU and raise that issue.
And they did. They did that. Whether the FCC
Dish has done that. The FCC has not yet responded to that request. I think part of what's going on is probably the FCC is waiting to see what the ITU is going to do with the file and whether whether in fact it will confirm compliance.
Okay,
isn't that peculiar? I mean, if they wait till the ITU to confirm compliance before forwarding a letter that says that for reasons that you may not have thought about, it's out of compliance.
Well, I think if I understand it correctly, the disagreement with SpaceX and between SpaceX and Dish, as articulated in the March 6th letter, goes to how the ITU's particular rules apply for putting together the input. So I think the assumption is that once the ITU takes a look at the input files, if it has a different view, if it shares Dish's view that there is a problem with those files, that will come out in the analysis.
But they would have to make that determination without the benefit of Dish's files.
That's right, Your Honor. Yes, but they will have all of the other files. And part of Dish's argument is that SpaceX's combined file is somehow different from the system it was describing in the 18 separate filings, and that it used a different avoidance angle, a technical term that essentially relates to the way the transmission beam is directed to an Earth station, and the potential for interference is related to that. Again, I think the information is all in front of the ITU, and if it believes there is a problem, presumably it's going to find that problem.
Now, when the FCC incorporates these ITU standards into its regulations, does that also include any kind of future discretionary decisions that the ITU may be applying with respect to standards?
Well, Your Honor, if the ITU were to alter its or amend its standards, and my understanding is there is a proposal under consideration to actually raise the power levels. But if that were to happen, the Commission's incorporation by reference refers specifically to the 2016 version of the rule. So the Commission would have to go through another procedure to specifically adopt the new power limits. So this isn't a process where if the ITU keeps changing its rules, the Commission would just blindly apply them. This is focused, the incorporation was to a specific rule adopted at a specific time.
And I just want to be sure, on that expert report, you're saying the FCC would not be looking at the challenge. Only the ITU would, and then it would either give certification or not?
The FCC wouldn't look at Dish's materials or any third party's materials. And the ITU, just to be clear, what the ITU has before it is the SpaceX files that the FCC has passed on. It does not have Dish's competing report. But what the ITU does have, of course, once it has SpaceX's files in front of it, it can apply its software. And if it finds, as Dish claims, that SpaceX has put together its files in a way that is contrary to the ITU's rules and procedures, the ITU can make that finding.
Do you believe that, so did Dish preserve this issue before the FCC, in your view?
Which issue, Honor? The subdelegation?
Yeah.
As I understand it, and I did review this issue. I don't have the site in front of me. Mr. Michalopoulos can provide it, but I am relatively certain that Dish did preserve this issue because it learned from the Viasat case where it didn't preserve the issue and tried to raise it, and the court quite rightly dismissed that claim under Section 405 of the Communications Act. We don't believe that sort of forfeiture happened here, which is why we didn't raise the issue. If there are no further questions, I'm sorry, go ahead. Go ahead, Your Honor.
Certification. Does FCC have no duty to look at any information that would undermine ITU self-certification?
Does the commission have any duty to, again, Your Honor, I think its only duty here would be consistent with the Animal Legal Defense Fund case if the commission knew based on its own experience with SpaceX that SpaceX was making a misrepresentation here, it could take action. It does not look at third-party studies or reports. And I think it's relevant
that's inclusive of waiving any pre-certification or pre-approval requirement?
I'm not sure if I understand your
Like,
question,
in other
Your
words,
Honor.
it seems like there's kind of two steps. Like you would have your self-certification, but then you would also, before the launch actually occurs, there's another step in there. So you wouldn't even look at it then before the launch?
We would not look at it before the launch, but again, as the commission has emphasized, SpaceX would proceed at its own risk under the partial waiver because there's a possibility if it launches and then the ITU later makes an unfavorable finding, then SpaceX will have to reconfigure its system to come into compliance.
Takes care of itself in the process.
Yes, which is precisely what the court found in Viasat. And Dish claims that this case raises a new issue in that it claims that it's raising an issue that this waiver has left it unprotected for a period of time. But if you go back to Viasat, the court actually considered that argument because Dish said, a future finding by the ITU doesn't do anything to help us if there is present interference. And the court said, among other things, first of all, the certification itself provides some assurance of no harmful interference. Second, if there is an unfavorable finding at some future point, that will require SpaceX to come into compliance. Third, in the meantime, while ITU review is pending, there are still regulatory channels available if there is actual interference for a party experiencing interference to report it to the FCC, and the FCC and its Enforcement Bureau would then take appropriate action to eliminate that interference.
Okay. Kept you up here for a long time. Any further questions?
No, thank you.
Okay, thank you.
Thank you, Your Honors.
Good morning, and may it please the court. I'm Rachel Proctor-May for the FCC, and I'll be addressing the issues that are raised by the International Dark Sky Association. And if I could, I would like to proceed straight to the merits. The standard, as Your Honor recognized, is whether there may be a significant effect. The standard is not whether there may be any effect at all, because that would set a bar that is so low as to be meaningless. And the commission reasonably concluded and reasonably explained that as to each of the categories of effects here, that standard was not met. So as to astronomy in the night sky, the commission looked in detail at the record, both for the NEPA question and under its obligation to ensure that this license was in the public interest. And it assessed the advanced technologies in the SpaceX Gen 2 satellites, which were specifically engineered to minimize brightness. And it imposed a number of license conditions that were aimed at further minimizing effects on astronomy in the night sky. As to reentry effects, the commission reasonably relied on two studies that were commissioned by the European Space Agency, and it explained why it relied on those studies. And then, of course, as to launch emissions, the commission relied on the series of environmental assessments that the Federal Aviation Administration had prepared, concluding in findings of no significant effects.
Ms. May, I know the commission said it wasn't resolving the question of whether NEPA reaches into space. But I mean, isn't that a threshold inquiry? I mean, if we're going to reach the merits, I guess you don't want to talk about standing, but I mean, if we found that there was standing here and we reached the merits, I mean, isn't that a threshold question we have to decide?
So, I mean, as you recognize, for purposes of this appeal, NEPA applies because that's what the commission assumed without deciding. But
we don't have
it's
to
not
assume the same thing.
right. We don't see that as a threshold jurisdictional question. It's really a separate statutory question. So the question that the commission answered is whether there may be a significant effect. And so because there was no significance, it didn't have to go to the second step and ask whether any of the effects of the space activities are effects within the scope of NEPA in the first place. So one of those questions doesn't necessarily have to precede the other.
Do you think NEPA does apply in space?
The commission didn't reach that question.
You're not.
It recognized, it recognized that there are novel issues that are raised by that question. For example, is sunlight as a source of reflectivity within the scope of NEPA? That how does the extraterritoriality principle apply? What do you do with effects that are purely in space, such as orbital debris? But again, the commission did not reach that question.
Can you just help me understand the redressability question here? Because so the FCC is, one of the many regulatory entities that regulates these SpaceX satellites, right? So if, how is there redressability here? I mean, if the FCC were to do an environmental assessment as the IDA petitioners want, and say the license wasn't granted, would that redress their harms? I mean, the harms of light pollution from a satellite already having been launched into space?
So as you recognize, there are two licenses here.
I assume
at
least two.
At least two. The Federal Aviation Administration licenses the launch of the rockets that carry the satellites to space. And so then once it's up there, the satellites are released into space. And what the Federal Communication Administration licenses is deploying and operating those satellites. So the SpaceX satellites wouldn't be able to be used to transmit communications, which is their purpose.
So
if they were sent up there,
would they be dark then? Like if the FCC didn't, I mean, would
I guess
emitting light, because
I think
that would not then redress their problem.
Well, I think the question would be whether SpaceX would have a reason to send them up in the first place if they couldn't be used for anything. And I don't know whether they could be used for anything.
Given the way that the provisional certifications work, presumably they may launch into space before everything is finalized with the FCC. And if the FCC determined not to license or to take back their license, would that redress their harm?
I'm sorry, Your Honor, if the license were rescinded at some point in the future.
When the satellites are launched. So if the satellite is launched and then say the ITUs or, something comes back or they just determine that there are environmental effects.
Right.
So they revoke a license, pull back a license. Would that affect their harms?
To the extent that that SpaceX could no longer use the satellites for these communications. Yes, the satellites would still be up there. And there are about 1,500 satellites that are up there already. There was no stay in this case. And so the satellites are already being launched.
And so if the FCC license were to be taken back, would that prevent the light pollution? Would the satellites have to come down? I mean, the redressability here is very murky.
Without wanting to make association arguments for them, I think standing is typically assessed at the time of the action. So I'm not sure if the fact that it might be revoked in the future undermines their standing.
It's not that it would be revoked in the future, but what they're seeking essentially is a NEPA analysis that might cause the agency to make a different decision. And so the redressability, they have to show some causal link between doing an environmental assessment and, that being able to redress their harms, which, one of their harms is light pollution?
So I mean, there's two ways that this could turn out. There could just be a remand without vacatur, which we agree with SpaceX would be appropriate if we even got there, which obviously I don't think that we should. But if there were
Constitutional, but okay.
Yeah. If the license were vacated, then I don't think anything would require the satellites to be taken down. I do not think they could be used for their intended purpose. And
if they were used, would they no longer create light pollution?
I think that's a very difficult technical question because a lot of what affects the light pollution is, they're metal satellites that have specific coatings on them that have specific reflective characteristics, which of course were engineered to be very minimally reflective. And they also operate in certain ways to minimize reflectivity. So there's a big solar array.
It sounds like it turns on whether they're transmitting. It's just the satellite itself.
That's correct.
So maybe there isn't redressability here.
We haven't addressed standing. We don't have a problem with the court deciding on standing.
Now, would one causal link be that the FCC could have had more stringent conditions in terms of mitigation? Because
the commission definitely has a lot of options at its disposal if the Gen 2 satellites don't perform as they're expected, or if the brightness mitigating technologies don't work as expected. The commission could enforce the conditions that it imposed. It could modify or even revoke in a very extreme circumstance the license. I don't think anyone thinks that would happen here, but it is an option, and it can impose rules. So there are all sorts of things that could happen in the future that might affect how these satellites perform. But what the commission did conclude in this case is that in this order, is that this set of mitigating technologies and license conditions would be sufficient to avoid significant effects. And it relied on an extensive record. It explained why it was relying on what it relied on. And that's all that is necessary to uphold the order. And we would ask that the court do that. And if your honors have no further questions?
Any further questions?
No, thank you.
Thank you.
May it please the court, Pratik Shah for intervener SpaceX. I'm happy to address either set of issues. First, the NEPA or the DISH, if the court has a preference. Okay. And then let me start with the DISH issues. I think Your Honor, Judge Rao has it right. Their real beef is with the FCC rulemaking in 2017 that adopted the ITU certification verification methodology. But this court made clear just last year in Viasat that DISH cannot collaterally attack that regime in licensing. And they have several different arguments that they try to say is not a collateral attack, but each of them boils down to a collateral attack on the regime. If you actually apply the 2017 rulemaking as it's written, this case is how it would transpire, and it did transpire. You have step one, the DISH self-certification. And by the way, the SpaceX self-certification. And SpaceX made the self-certification on both submissions on the 18 separate files first, said, look, that satisfies it. And then when the commission said, actually, we want to make sure that you're combined in one file does it, they made another self-certification that they put it together as one file, ran the ITU validation software, and certified it is. And FCC relied on that certification, the very one that DISH is asking for, that it be one aggregate file.
So how are DISH's results turning out differently?
So,
practical matter.
Right.
Can you maybe shed some light on that?
Yeah. So again, this is not in the record that's before you because they wrote this in a March 6, 2023, but it is in the JA if you want to see that. letter, and you can confirm this with Dish's counsel, but my understanding is they don't actually disagree that the files that SpaceX submitted will get an ITU validation, because SpaceX ran the software, the same software, and got the green, let's just say green light, right? They got the green light, and they don't dispute that in their March 2023 letter, that in fact, it does comply with ITU validation software. My understanding of their objection is they say, look, in the input files, SpaceX, contrary to their reading of ITU rules, use different angles for the mask angle and the avoidance angle, and they say that angle has to be the same, and SpaceX use different angles. Now, SpaceX will tell you, no, you don't have to use the same angles, and in fact, ITU has approved many different constellations that don't, in fact, use the same angles, and it doesn't make sense to use the same angles here based on how SpaceX runs its system. That's obviously a technical disagreement based upon interpretation of ITU rules, based on their own.
That's a disagreement about what inputs go into the ITU software.
Of the inputs that are in the files, they read the ITU rules differently. This is like the quintessential reason why the FCC in its 2017 rulemaking said, we are going to let the ITU apply its own software to the files. If they are right that the ITU rules require the same angles, obviously ITU will see that in the files that they use, and they can adjust it, and ITU will make that known. And so this is exactly the sort of thing that FCC said, and it explained this. It had a full notice and comment rulemaking in 2017. It got a lot of favorable comments. It got a lot of objections. Dish did not participate, didn't submit comments. In that 2017 rulemaking, at the end of the day, the commission said, look, we're not going to even ask for the technical data files, because if there are technical disputes, the ITU, which does this not only for the United States constellations, but it does it for every country. It's a ITU is a UN agency. And it said, look, it makes sense. Rather than have variation country by country and applicant by applicant, the US doesn't have a monopoly on space. There are foreign licensed satellite constellations. There are US licensed constellations. And that's why it makes sense to have an international, not only adopt the international standards, but it's common sense that you would want the entity that created those standards, that's fielding applications from countries around the world, to be the one that runs it, so it runs it in a uniform manner and resolves these sorts of disputes.
Can you answer the question I asked FCC counsel, which is there a formal relationship, like legal relationship between the US and the ITU by treaty or executive agreement or something?
Yeah, so I am not aware of like a Senate confirmed treaty.
Some executive agreement.
Right. What I do know is that this rulemaking obviously has the United States, through the FCC's rulemaking, makes those ITU standards binding. They do have participants that participate in the conventions that come up with these ITU standards. I don't know formally whether there is a formal agreement beyond what FCC has agreed to make their standards binding.
Was there a resolution of the issue when you were talking about the angles with respect to the 2016 ITU decision before the FCC adopted it?
The 2016, no, that in the 2017 rulemaking proceeding, as I understand it, that was when FCC said we're going to incorporate the ITU standards, and then we're going to have the verification done by ITU. Presumably, then ITU would adopt whatever procedural rules it has and apply those to whatever verification. But I don't recall any specific discussion about that particular rule that Dish contends SpaceX is interpreting incorrectly, and SpaceX contends Dish is interpreting incorrectly. If there are no other questions on the Dish aspect of the case, I'm happy to shift to the NEPA aspect of the case. And there, Your Honor, I think it's pretty straightforward. The court is not assessing de novo whether all satellite constellations, past and future, pose any conceivable risk of any impact. The regulatory framework here is pretty clear. There's a categorical exclusion. The agency, again, did that through notice and comment rulemaking. And again, you heard counsel for IDA call that an antiquated assessment. Again, you have essentially what's a collateral attack on the categorical exclusion. The categorical exclusion says these sorts of activities ordinarily don't have a significant impact. That's step one. The FCC regulations then allow a challenger to overcome that categorical exclusion, but it can only do so if it, quote, sets forth in detail, end quote, that's the FCC regulation, how the particular action at issue may still cause a significant impact notwithstanding the categorical exclusion determination. So that means here, IDA had to show why the 7,500 satellites that were actually approved based on its record with all the mitigation and compliance conditions, why it could still have a significant environmental impact. And then we get to step three. That's the traditional APA determination then. Hey, did the agency look at the evidence? Did it consider it? Was it arbitrary and capricious in saying whether it satisfied that standard or not? And here, we're not even close to the arbitrary and capricious line. It looked at all the evidence. It made a considered judgment. And they're legal, though they do make one legal argument beyond arbitrary capricious, which is to say that you can't look at mitigation. They say mitigation is indicative that there will be a significant environmental effect, but that's contradicted directly by the CEQ regulation on NEPA. And CEQ is the body that is primarily in charge of NEPA. That's at 40 CFR 1501.4B1. And that regulation says, and I'll just read it to you, if extraordinary circumstance is present, the agency nevertheless may categorically exclude the proposed action if the agency determines that there are circumstances that lessen the impacts or other conditions sufficient to avoid significant effects. That's precisely the determination that FCC made here. They said, look, with all the mitigating conditions, and including the ones that we're adding to the license, here you're not going to get the significant effects. And that is the record on which this court should assess it. Thank you, Your Honor.
We'll have rebuttal from Mr. Mudd.
Thank you, Your Honors. I'd like to briefly address a few points. One, we are considering or talking about significant effects, not just effects. And while there was a comment made with respect to the categorical exclusion, where the attack on that's not necessary here. But I'd really like to focus back on the redressability, and particularly, Judge Rao, the questions that you've raised. To begin with, the substantive harm for IDA arising from the unlawful order is the allowing significant environmental effects, principally the diminishment of the dark skies, and thereby affecting its interests in protecting the dark skies. Clearly, these fall within the definition human environment, and the NEPA analysis extends to cultural and aesthetic issues and focuses on the present and future generations of Americans. Now, you've raised two issues. Essentially, part of your question, I think, is even if we look at this and the FCC reverses its order, which I would first say that the redressability issue largely can be overcome under Wild Earth by simply analysis, is the challenger's injury redressable if the agency should change its mind, if it adequately considers the environmental concerns? And we argue, yes, it could deny the application. It could order additional mitigation requirements reaching the ideal magnitude that astronomers would like in terms of brightness, could limit the number of satellites and thereby minimize the impact. But what are those satellites already launched? One, they could not launch anymore. But as to those that are already up there, if they're not operating on, just as SpaceX does on Orbit Rise, and turn the satellites so that the solar reflectivity is significantly minimized because they're not yet using it, they could do the same thing with the satellites that are already in orbit, should the FCC change its mind. And I see my time is out, so I thank you all for hearing our arguments.
Thank you, Mr. Mudd.
May it please the court, and let me start with JA 230 is where actually SpaceX rebuts are non-delegation arguments. For some reason, and cites to a September 21 letter that we found. For some reason, the letter is in the record, but did not find it in the joint appendix. But
There's a letter where you raised that issue?
yes,
Okay.
yes, yes. And so,
Submit that to the court. If you could submit that to the.
of course. So on subdelegation and rubber stamping, I heard neither counsel for the FCC nor counsel for SpaceX try to rebut the fact that what they presented as the ITU favorable finding that resolves the issue, makes it moot, is for the wrong system. System was filed in 2019. So it doesn't indicate that the FCC has considered the combined generation 2 system, because it didn't. And therefore, they have not communicating the finding to the FCC, as they would have had to. And so where does that leave us? And that goes to the heart of rubber stamping. The FCC cannot do anything, cannot subordinate the FCC, the ITU. Subordination is, of course, a crucial test of what is an improper subdelegation. This cannot do anything. We cannot go to the ITU, as Judge Ginsburg was asking, and say, look, your rules are being violated. You should not ignore that. We cannot appeal the finding. And this makes us indistinguishable to the public in the Gutierrez case, the Judge Santel case about the whales, where Judge Santel said, you cannot punt, the Coast Guard cannot punt to the International Maritime Organization for the vessel routing directions on how to not kill whales. Why? Because this would rob the public of its right to challenge those determinations under the Endangered Species Act. That's what's happening here. And so if there is improper subdelegation, it's unconstitutional. And to the extent that the rule implicates this subdelegation, it's not correct or concordant with the Constitution. Now, we don't believe that the rule needs to be read that way. And that goes to the colloquy that you and I had, Judge Rao. As to the 18 ways, Judge Ginsburg, you asked a question about whether the ITU might have wanted to see both. The answer was not quite accurate. To give SpaceX the benefit of the doubt, this 18-way arose from some difficulty in another band, the Ka band, not the 12 gigahertz band. There was no reason that they would have had to split it for this spectrum. And then you asked about
Excuse me, Counsel, didn't we hear that they were requested by staff, ITU staff, to submit that way?
They say that they were requested by ITU staff to submit that way for the Ka band, for this different spectrum. That's where the issue was. The ITU staff didn't tell them anything about this band. That's what they chose to do. And then as far as the disclosure after the fact of the submission is concerned, Mr. Carr said transparency. The real answer given in the order was, this is an important protection from interference for DISH. But for something to be a protection, you have to be able to do something about it. It cannot be a protection when you can only hang it on your walls or archive it away, which is what seems to have happened here, because our March 6th subsequent showing has fallen on deaf ears and has had no effect whatsoever. Thank you.
Jason.